who goes by "This is a public service" on YouTube.
This is a public service.
This is a public service.
Good morning, everyone. Gavel. I'm gonna gavel us in. Good morning, everyone. Nice to see you all. It looks like we have quite a full turnout for the third task force on rules of Supreme Court meeting. As with our first two meetings, we probably have more material to cover than we have hours allotted for today, but we'll do our best to make quick and meaningful progress. Well, housekeeping matters. We have at least one new face in person and one appearing on camera. And I'm sure we will see his face at some point, but I'll begin with introducing Mr. Matthew Kelly from Ballard Spahr, who is appearing as proxy for David Vodney, and then Mr. Michael Morin of Osborne Maladon, who will be appearing as proxy for David Rosenbaum. So welcome to both of you. We look forward to hearing from you. We invite you to be full participants as proxies for our very capable routine members. So welcome and nice to see you. Since by way of an update, since the September 16th meeting, all of the work groups have been proceeding apace and collectively have met 9 times. Each of the meetings was a full 3 hours. And each work group has already scheduled the next meeting. So thank you for all of the effort and commitment in moving ahead in the work groups. Obviously, that's integral to our ability to accomplish our task. Way off topic, by reminder, we will have a lunch available, $5. Veronica, for $5, you can participate in the lunch at probably about the noon hour. So with those introductory remarks, I will pass the baton over to Justice King.
Well, good morning, everybody. So the next item on the agenda is just the approval of the September meeting minutes. The draft minutes are in the packet beginning at page 4 of your meeting materials. Does anybody have any corrections to the meeting minutes?
Perfect. You list that here, or you caught the one on civil appellate?
We've already changed that in the Veronica's version of the minute. We added the word appellate for reference to errors on the rules of civil and procedures. Was omitted. Yeah.
So the meeting minutes appropriately reflect that change.
Not packet version.
Oh, not the packet version.
Version is wrong.
No. Thank you. Any other corrections or additions? Seeing none, I do need a motion. This is an action item, so I need a motion to approve the September 16, 2025 meeting minutes.
So moved.
Second. All those in favor say aye. Aye. Any noes? Okay, motion carries. The meeting minutes have been approved. So I think we're now on to item number 3 on the agenda.
Yep. Item 3 concerns Supreme Court Rule 122. As with our first 2 meetings, the bulk of our time will be spent with work group presentations on various assigned rules. We're going to begin today with the sort of unofficial work group, the Supreme Court Rule 122 work group. Marita Mathis, and for those of you who don't know her, she is an assistant counsel for AOC here, and she has volunteered to present the work group's efforts on Supreme Court Rule 122. You have in your very expansive packet of materials today. Work group 122's materials begin at page 18, so you have those for reference. Now we've decided to begin with work group 122 today for a timing reason. As you may recall, work group 122 is tasked with presenting changes to revisions to Rule 122 and 122.1. However, we're operating on a different timeline. And so the objective for this work group, which ultimately the approval authority rests with this task force, is to have a petition prepared by the end of the year for those two discrete rules. And so in order to accomplish that, we're going to begin with the Rule 122 work group presentation. Marita is not asking for any official action from the task force today. However, we're requesting and demanding that we get your considered judgment and thoughts so we can walk away with the ideas of making revisions that hopefully will meet with your satisfaction when we represent the rule petition for the task force approval on December 9th. As I noted, this is just the presentation today just concerns Rule 122. At the next meeting, it's a rather discrete Rule 122.1, but we will present our revised Rule 122.1 also at the December 9th meeting. So I think what we should do here, and I've done it in other committees when we have a lengthy meeting and we're presenting rule packages. I don't see any member of the public here. Is there anyone online? We don't need, we have a call to the public to speak on specifically on Rule 122. So if no one's here, then consider the call to public accomplished for purposes of Rule 122. The reason that we did that, I'm surprised that we don't have someone appearing. Rule 122 and 122.1 essentially concerns reporting and broadcasting from a courtroom of matters. And in certain parts of the state, we've had a number of citizens who are interested sort of in advancing of what they would describe as citizen journalism. Oftentimes, the member of the public may be someone who has a grievance with a particular judge or a particular matter. In our view, these activities have often been disruptive to the court proceedings in violation of the rules. Nevertheless, when we've reviewed the rules, there seem to be some unintended ambiguities which give these individuals some standing to argue that they're entitled to use, for example, an iPhone to record and broadcast because it's not a camera, for example. So we've made a number of revisions to bring the rule up to speed, up to date, but also to address some of, I think, the unintended ambiguity in the rule. Before Marita begins with her presentation, and I have to give Mark credit for this quip. He said that the video is worth 10,000 words, and I assume that's because a picture is worth 1,000, a video must be worth 10,000. But we began our work group, Rule 122 work group presentation with a review of a few YouTube videos that were taken by these citizens in court proceedings. And I think that the disruptive nature of some of this activity speaks for itself. So I thought it would begin by having Veronica show some clips from some of these videos before Marita begins her presentation. Oh, just one video. Okay.
No, I'm on it, dude. Don't you worry.
Hold up, man.
I'm wondering about your supervisor.
No, you're gonna stand right there until she leaves.
Okay, whatever, dude. I'll leave. I'll gladly leave. Because no, I don't. No, I don't. What law is that? What rule is that? Nope, let me see it. Give me a copy of that. Give me a copy of those procedures. It's that simple.
Turn off the camera.
I'm leaving.
Turn off the camera.
I'm leaving.
Turn off the camera.
I'm
right now.
leaving. I'm leaving.
Turn it off.
I'm leaving.
Alpha 7, he's refusing to turn off the camera.
I'm leaving.
Turn off the camera.
I'm leaving.
Raise the sound level for max audio right now. See if there's some other way we can amplify it.
I'm leaving. Let me go. Let me go. You're not recording. What was that? Let me leave. Let me leave. Hold on, hold on. Excuse me. Excuse me. Excuse me. Excuse me. I'm leaving. Fuck you guys. What? Yeah, you're damn right I'm recording. I'm coming. You can touch me. Yeah, I can. Yeah, I can. Look at the sign right here. Audio visual recording in progress. Yeah. You guys don't know the law either.
Well, so you get the flavor of what has been happening in certain courts with certain groups of people, and having the judge have to debate with an individual, or as a proceeding commences about the propriety of recording it with one's iPhone is really untenable, and so we revisited the rule again to remove some ambiguity and to bring the rule up to date to balance, the individual who is attempting to report on a court proceeding, to balance First Amendment rights with the court's interest in maintaining order and quorum to avoid disruption of court proceedings. So,
well, I don't know how much of a philosophical question you have to get into this, but if the problem is disruption, then you deal with somebody who's disruptive with the camera. If the problem is you're just going to ban all recording devices, which I think is what the rule is, doesn't that have some other problems and implications? I mean, they're supposed to be open hearings.
no, it's not. It doesn't ban it. It is up to the discretion of the trial court judge whether to allow recording, and that remains consistent throughout the rule. There's some ambiguity because the rule was crafted with implicit interest in regulating organized news outlets with large cameras, and so it's up to the discretion of the trial court. And I think it's fair to say that there's even a presumption that recording may be permitted, but there are express exceptions that involve, safety of parties, disruption, things of that nature. So we have not, in the revisions, as you will see, we have not departed from, I think, the thrust or the intent of the original rule. It's mostly just cleaning it up and clarifying the way the rule was written before, because it contemplated essentially cameras, a technology like an iPhone that's capable of recording and broadcasting while being held in one's hand. It's easier for someone to surreptitiously or even openly record with a phone. And there was some confusion. The ambiguity I was alluding to had to do with whether an individual who is recording and broadcasting a proceeding with an iPhone, whether they're required to get the courts to notify the court and to get the court's approval. And the way that the rule was written, arguably it would not apply to a citizen with an iPhone, but it would apply to journalists, for example, news outlets. And I think that seemed to be a drafting error. There's just ambiguity there. So these individuals, to be fair, had a reasonable argument. They found a loophole rule that said the rule doesn't apply to them. They don't have to get the court's approval or notice the court that they're going to be recorded.
Yeah, I mean, I suppose you can make a rule that the video quality should be better before anybody's allowed to do it. That is an issue, but I mean, courtrooms are supposed to be open unless there's a specific reason to close them. And having somebody with an iPhone record should be part of the nature of open proceedings. And I don't know that we really want to discourage that. If somebody's disruptive, then you deal with somebody who's disruptive. But if you just have some judge that bans everybody all the time, I'm sure that's what we want to do.
Yeah, well, then, I mean, that is always subject to judicial challenge if there's a denial. But I think, but again, the rule, as you will see, the rule has not changed fundamentally. And again, if you're, urging a completely different approach, then we can all discuss that for sure. Yes.
I've had personal experiences with this. And let's say you have a case where you have a victim and the person with the camera is holding the camera right at the victim. Let's say it's a sex case or a molestation case, or they could film the jury. So we don't allow people to film juries.
Yeah.
It's very disruptive and we don't have the resources. It takes 3 or 4 security officers in the courtroom to police this. We simply don't have the resources if everyone's doing this all the time. And it's just a nightmare. So I don't think the rule was designed for this. I think it was designed for like in a family proceeding. If you don't want to pay for a transcript, you could record the hearing. So you'd have a copy of yourself. But I think the rule needs to be changed because it's extremely disruptive. We just don't have the resources to police that kind of behavior.
There is a possible option. You'd have to work. There are already security cameras all over the place. You could have them just trained where you want to, certainly not on the juries, not on victims. You can have them controlled and say, okay, we don't allow cameras in the courtroom. We don't allow cell phone cameras, but everybody has access to court proceedings over days.
Security cameras. It'll record audio.
Well, you'd have to, I mean, there might be a budget outlay problem, but you could create a system where you actually have proceedings available to, and so you don't get to record your own, but everybody has access to the same, like you walk in the courtroom, you can watch, there you go. And then that's good with a lot of the problems.
I think, and someone can correct me, aren't the recordings made of proceedings in courts?
Yeah, so
available
MPR
in public
records
records.
when we're on the record. So we don't,
Yeah.
We like to go off the record sometimes because there's just no reason to record everything, Someone could sit in the courtroom and watch. It's open. But it's just the cases that we deal with, a lot of issues, and these people are very aggressive and they're doing it to be disruptive.
Yes.
And so the rule, I think, that didn't contemplate this technology. We do have security cameras. They don't have recordings. I also live stream my hearings over YouTube. It's a process that we developed during COVID to give the public access. And I think it's a good idea. So you could listen to the proceedings and then people will record those and put those on YouTube too. We can't prevent that. And that's up to a judge's discretion. But the idea of just having someone with a camera that could just go around and take pictures, it's just too disruptive. In federal court, you can't do that. You'd be arrested. They wouldn't put up with that. And we're a little different than federal court, but you don't have a constitutional right to record.
I just wanted to point out, if the thought is to
prohibit recording, but give everyone access to the, essentially the webcasting of proceedings. For professional journalists, for television stations, that would be a step backward because the video quality and audio quality from those is not the same as the professional equipment that they use when they have, one camera in the back corner of the courtroom. So I would want to make sure that if that's one of the solutions, that there still is a way for the professional news media to get professional equipment in there, as well as not having to just rely on the web casting.
Yeah, that's not contemplated by the provisions. So
Recording in progress.
the intent is to make to bring it up to date to deal with the fact that anyone can now effectively carry a camera and record and broadcast from a device, redefining, updating the definitions of devices.
The only thing I'd like to add is somebody did bring up security cameras for hallways and things like that. And I did have an incident recently where there was an altercation between an attorney and a opposing party, and they asked for security footage. It was produced very quickly. But it's also not one that I had the authority to give. They had to go to our security, to the MCSO. And so I don't think we have any separate control over that. It's really much more MCSO.
Judge, I'm pretty sure that reporting was a limited jurisdiction. And 122 was written, I think, more in line with professional media. And there's a notice requirement. I think you have to give notice like 24 hours, something in advance. That doesn't seem to be working for the lower courts. These people are coming in the day on the draft and not requesting benefit. I don't know if we've dealt with that.
Yep, we have. We've been expanded the notice period and deadlines that further out from the hearing for several reasons. One is for to make a principled decision and record if there is a denial, to insulate it from but this is all laid out. Marina, would you like to part of the presentation?
Sure. Okay, so the markups start at page 38 in your materials. To the extent it's easier to look at a clean version, that will be on page 46. So kind of just walk through the rule and comment on where the changes are at, what the significance is, and go from there. So looking at provision A, you'll see that the first sentence was revised relating to preserving the dignity of the proceedings, the clause added in there. That was actually moved up from what is currently in 122E. So that's nothing new there, but it was moved up to signify the prominence of that. There's also a strike through on the provision related to the court being required to use reasonable means to inform the public of the provisions of this rule. The work group felt like reasonable means was sort of a contentious topic. And even if the sentence is removed, that doesn't preclude the court from advising the public of the requirements. But there's not really a good reason to have it there, other than it's a good practice. So the work group felt like it was appropriate to remove that. Going on to section.
Rita, we have a question down at the end.
So specifically with that provision, I think of criminal court, and in our courtrooms in Pinal County, there's specifically a posting that says, if you talk with an inmate, it is a crime and you run the risk of being prosecuted. Did you consider actually just requiring that the courtrooms post this rule outside so there is no ambiguity, there is no misunderstanding, just a summary statement of Rule 122? That way it's not in there, but it's available for the public.
Well, I think most courthouses right now today have such a sign posted. The ones that I've been to have. It wouldn't preclude a court from doing that. Putting that into a rule is a requirement. I suppose that would be a policy decision. Not to say that that's a bad practice, But just for requiring signage, I don't know that any other rule really requires that.
I was just thinking the lower
Yeah,
court problem that you were discussing.
yeah, I mean, I think it definitely could be something that the lower courts are advised of as a practice, but again, putting it in rule, I'm not sure that that's where it belongs. And certainly, if it's a requirement at some point, the rule, may not be applicable if the report's already done it. And I would defer to a policy decision, but signage is a good idea, but maybe not for rule. Any other questions on that? Okay, so the definition portion, I'm gonna go over this. I'm gonna go over briefly what the revisions to recording device are, but I want to save the substantive discussion on that definition until later, so that you can see how it's used within the rule to determine whether it's appropriately defined as proposed by the work group. So the first revision to this section will delete the definition of camera. So that is going to be consumed by the definition of recording device. The second definition that's being revised is courtroom. So as a reminder, Rule 122, that's related to recording in the courtroom. 122.1 relates to recording in a courthouse. So the definition of courtroom is revised to include virtual settings, which would include, Teams, Zoom, any virtual platform, so that it's clear that is considered a courtroom that falls within the purview of Rule 122 related to recording. The term cover and coverage is deleted from this rule. And again, as we've already stated this morning, this rule was largely geared toward news media. So revising this rule so that it applies to a broader audience, it really doesn't make sense to use the terms cover and coverage anymore. Those have largely been replaced with either record or use a recording device throughout the rule. Judge, the definition of judge, no changes. The definition of person, that has been revised to replace organization with entity. And that's based on a proposed draft rule of Rule 2 that defines person as an individual or an entity. So it was changed here for consistency throughout this rule set. Number 6, personal audio recorder. That was deleted in its entirety and again is consumed by recording device, so that everything that falls under this rule is treated equally. The only reason that it was parsed out before was for the request and notice requirements, which again, as this rule is being proposed, be amended, everything will fall within the same context, same procedures, regardless of what type of device it is. Number 7, a proceeding. That was changed very, very slightly from a court case that takes place in a courtroom to conducted in a courtroom to account for virtual proceedings. Very slight there. And then we get to, I'm going to skip over recording device for a second. Victim, that was just changed to add criminal rule 1.4. Very slight, sort of a technical change there. So recording device. So this was pretty significantly expanded to include technologies that exist today. So it includes apps and applications, recording devices that use artificial intelligence, and essentially any device that can be used to capture, record, preserve, transcribe, any broadcast the proceeding at all. So again, very, very broad to include all devices. And I'll come back to that at the end, but just so you know, that's the intent of recording device as we go through the rule.
I thought about maybe putting such as iPhones and such as, and just go ahead and list a few things. So it's.
We did list a few things, but we didn't want to get too specific. So it says, includes camera, apparatus, or application. So those are the few examples, but we didn't want to get too specific on that with technology changing.
Example, BlackBerry, right? We were here 10 years ago. We'd be talking about BlackBerry as another.
Yeah, we want the rule to somewhat stand the test of time as technology advances. So we sort of went back and forth on that, but we landed with a camera generally, an apparatus or application. App is as far as we got, you know, sometimes it's not the actual device, camera or an iPhone that's recording or preserving, but it's an app within that. So we try to be very, very broad there.
There might be some advantage though of saying cellular phone.
Yeah.
It's so common and they're gonna last for a while. But I know you now have these Google glasses and other devices. That'll always change, but to Bob's point, it just seems like folks who are coming in, they're all mostly, you know, always using cell phones. That way you wouldn't have an argument.
Yes, I should have crossed the room and then, Judge Metcalf.
I think if I'm understanding it correctly, and so maybe it's not needed, was since we've taken out coverage, I didn't know if broadcast needed to be defined, or is it now going to be, because I know one of the issues, or I think loopholes in the other rule was the device being on the person and even audio recording, which I think in the old days was more for a person of the media that might come in and they audio record it and they take the audio back to their office to write their article, you know, so they're not waiting for like a transcript and the story's like a month and a half old. But what we have seen is people under the current rule believe that they can record on their person, which I think this is trying to do away of, but they'll say it's not video, it's only audio. I can take the audio and put it anywhere I want because I didn't capture any images. I'm assuming this rule is trying to rein that in too. So maybe is that why we're not defining broadcast or?
Right. So it would be any device that's used to record audio, or it could be used to broadcast, or maybe used with other equipment that could be used to broadcast.
Now, if you're a party to the case, you would just need to follow the provisions in here. So let's say you did have a party to the case for whatever reason, they wanted to record it, just audio, they would follow the notice provisions.
Yes.
So this includes 8-track tapes and Betamax.
That's when it was written, it kind of envisioned.
Yeah, I mean,
Audio recorder.
you know, the personal audio recorder, I think of the little tape recorder that you take to college and record your lectures and then never listen to again, right? So those were treated differently. And for those, you just had to tell the court, you didn't have to get permission. Those are somewhat antiquated, and there's some confusion about, you know, if I'm just using an iPhone now to record the audio, is that a personal audio recording device?
Yes.
Well, I mean, I suppose, but it has further capabilities than that. And so the idea now is to bring the rule up to technology and treat everything the same. You know, I don't know how frequently people use just the personal audio recording devices anymore. My guess is that they're using something that's a little more advanced than that, such as an iPhone and such. I don't know why you would carry both. I don't know what the news media uses, but.
Yeah, I think the instances we've encountered in Maricopa County are, you're not bringing in the old fashioned personal with the little tape.
Yeah.
I still have one of those at home. But they are claiming, oh, I'm not doing any video, so I'm not violating any of your camera rules, but I'm not a party to this proceeding, but I'm gonna audio this thing and then take my audio, and while I don't have video of it, put it on my blog or put it on and this has even happened in protective order proceedings.
Yeah, so it would be all audio, you get permission from the court, regardless of what you're gonna do with it. All video, all broadcasting, all of that, you get permission from the court before you hit record. That's the way the full structure.
Just wanted to bring your attention that there are small devices now that people are wearing, particularly when they go into meetings in order to capture what's being said. And then it has an AI function to it that will summarize the meeting and provide notes subsequent to that. So we are kind of going back to those types of devices. But the way I read this rule, I thought that because that device includes or is a device that uses artificial intelligence, that was intended to cover those.
Yeah, it would be intended to cover that, and it's also intended to cover these AI note takers that are appearing in certain proceedings that we're hearing about, where it's not clear whether or not that AI note taker is actually recording the proceeding at all, but rather just taking the information and summarizing it and then spitting it out to the recipient. We're not really sure what's happening with that, but it would be that sort of scenario as well.
Lisa?
So I have a twofold question on what you were just describing. So when I look at C, where it says the request part, you know, the request to use the recording device. This section doesn't seem to define request, that doesn't use in writing, for example. Is there someplace else in the rule that addresses the form of the request?
That is going to be in B1, requirements for submission of a request.
And maybe I missed it, but I did see it say that it needs to be in writing. Did I miss that?
Yeah, it's in the paragraph.
Oh, okay.
Person who wishes to use
recording written.
device must submit a written or electronic.
But so was it intentional to not make it in the form of a motion so that it was more available to members of the public?
I don't think that we contemplated that it would be a motion.
And I'm just wondering why, because, you know, this is unique in that it doesn't require it to be.
Don't you have to be a party to file a motion?
You would have to be a party, so members of the public would not be able to file a motion. It would be just a request.
And do you envision that this rule requires them to identify what type of recording they're going to use? I know we've discussed what types of recordings are included, but would the requestant have to tell the judicial officer what they're going to be using?
You mean like broadcasting or video or audio?
No, I mean like what type of device they're specifically going to use. We've talked about security, for example, being concerned, and knowing what we have permitted a particular individual to do could help with monitoring general security in the courtroom, for example.
Yeah, so when we get later into the rule, that kind of identifies what the court can order, what types of requests, pooling, you know, if it's got multiple requests, where equipment needs to be set up. So I would like to come back to that in the event that those provisions don't address what you're concerned about. That's a little bit later in the rule.
Marita, what was the policy discussion of why recording or note-taking in a virtual meeting? Why is that a problem? What's the problem that the judges were raising?
Well, you know, I'll defer to the judges on that. I think there is some, that is the other side of the argument, right? Should there be?
Well, it seems impossible to enforce at the beginning. I mean, if you're on a virtual hearing and you just set your cell phone down and you can record the whole thing, no one's going to even know. But what I know it's come up, but what are the concerns we're trying to prevent?
Well, I think in some cases, you know, there's going to be like Judge Metcalf mentioned, you know, victims, jury, you know, restrictions in that sense. But overall recording, I mean, that's, you know, that is the question. That's a policy decision on, you know, should there be recording? The revisions to this rule really just kind of went with the policy that exists today, that if you want to record in a courtroom, you've got to get permission from the court unless it's a personal recording device, which is now swept under the policy that's always stood for other recording devices. So the change in the policy wasn't necessarily discussed. Whether we want to go that route, I think that's a larger discussion.
If somebody wanted to if somebody had an ADA reason why having an AI note taker, I feel like they can make that request. Or even if they just want to make the request and say it would help me because it's a complicated case. But I will say generally just having AI note takers drift in and out of hearings, I have concerns about accuracy. of the transmittal of the proceeding. And even video and audio are never perfect, right? But, you know, we've all seen when we see AI try to transcribe a conversation that there's always mistakes. So in particular, my thought is that if somebody says, I really want my AA note taker because it would help me prepare, I'd probably say yes, but I do want you to understand that the most accurate record of this proceeding is the video audio. And that AI makes mistakes, and I would probably lead off with something like that. But also, I don't know if you go on to, you know, virtual hearings that are being run on Court Connect or Zoom or anything like that, but when I see those AIs pop in, I've actually generally asked people, I say, does this belong to anybody? Does anybody need to use it? Most people say, no, I have no idea what that is. And so it's also, there's no indication when I'm running across this of who's using it, right? And so having the ability to say, okay, if nobody's going to claim this is theirs and say, this is my note taker and I would like to use it, I'm going to remove it. And I would like to be empowered to do that just because I need to know what the accuracy is of the proceeding that is being recorded. And I don't think that that's out of line. You know, and a live stream like Judge Metcalf uses, I think doesn't really run into the issues in the same way. I do want to say something real quick because I've been trying to, why are we using the word broadcast instead of transmit? And the only reason I'm asking about that is I could see somebody saying, well, broadcast means that I'm putting it out for like a big audience and I'm just live streaming this to, you know, my girlfriend or my family or something like that. If we are trying to encompass the notion of some live streaming, so they can say, well, I'm not recording, it's just live streaming. I also want to make sure we're saying, well, you can't broadcast. Oh, it's not broadcasting because it's just going to one other person. So I'm just a little bit concerned about the use of the definition of broadcast as opposed to transmit, or even if we could add transmit or something like that.
If you look up generic broadcast, it says relating to television and radio. Live streaming would be explicitly excluded. That would be the general interpretation that somebody would have. So if somebody came to me as a private attorney and said, hey, if I'm just live streaming, can I have my phone out there? And I'm not sure there's a darn thing we can do with this proposed rule because they're not recording it. It doesn't qualify as recording device because they're live streaming it. So I think broadcast is too narrow of a term. What term you use or define broadcast, I think maybe that was Jessica's request, was to define broadcast to include live streaming or something, or use a different word, but whatever word you use, define it up there to make sure that it's clear what they can and cannot do.
I was just gonna say something following. If it's, a lot of this is not enforceable. I'm seeing ads now for pens. You push a button and records everything and turns it into a transcript.
I mean, Mission Impossible had that too, though, right?
When that's all. But so, I mean, you're gonna get some of that. And I could see being in a hearing or a meeting just for myself, doing it, going back and seeing exactly what was said if I'm writing a motion later on.
Does that mean we shouldn't try to enforce against it?
No, I'm just saying that there is an issue with that. You have to post the rule, but I'm not sure how enforceable it really is.
I just think if we're going to have a rule like this that goes this far, we have to be able to articulate clearly why you're doing it. I haven't heard that yet. I don't know why a judge needs to know the accuracy of some lawyer taking notes. Maybe written notes, they may or may not be accurate. I'm not saying we shouldn't, but I think we've got to get better at why. Why is this a problem in open court?
So the problem is not with the lawyers. If a party, counsel representing a party requests permission from the judge, I think it's highly unlikely that the judge is going to deny that request. This is about individuals who are not parties, who are using recordings to harass other individuals, other parties. They're oftentimes a concern about the recording, as we've seen, the recording is manipulated, distorted, and then broadcast to harass parties, judges, others. That's the concern about the revisions or it's the focus of revisions to capture that. That's the concern. It's not about parties making legitimate uses of recordings and simply notifying the court, requesting the permission for the court. I can't imagine that a superior court judge is going to or the court judge, jurisdiction court judge is going to deny a request from a party. This is about individuals who are recording, transmitting, broadcasting information without the knowledge of the court. And if a person may violate the rule, and then they may post this, and then the judge will likely find out that this person has violated the rule in one of their proceedings. And to the extent that the person does that, then the judge is on notice to apprise the person of the next violation and then deny a request. I mean, I think that there is a manner, although imperfect, to enforce and deter abuse of recordings in trial court proceedings without the court's knowledge and permission.
Yeah, I think you're going to hit on without the knowledge of. Somebody is upfront about it. And by the way, you do have a problem with parties if they're pro per se. If you're a lawyer, you can control them.
Yeah.
For that. Maybe the key issue is anonymous recording, not being upfront about it. That's more the issue.
Yeah.
Maybe we should reflect that.
And that's how I read the rule to begin with, and its purpose from before, is that this is to give judges the tools to be able to control their courtroom, maintain decorum. And if you don't specify that someone has to request authorization for a particular type of device, whether it's a party or it's a private person, and then also have them tell you what they're going to use it for when they use an unauthorized device for an unauthorized reason, then a judge has the ability to take action if necessary. If you don't do those things, then the court's just left in a position of not being able to do anything because you didn't require specificity up front. So yeah, is this difficult to catch someone who's going to cheat? Sure, of course. But we don't decline to specify what someone should do just because there are people who won't.
Maybe that's my memory of Dave's questions. The way I read this was access is the question about public proceedings. You can observe a proceeding by being there in person, calling that conference call number, or going online to the Zoom, but you need permission to record or transmit.
Correct.
And that gets in that intersection of, I would like to record because Aunt Sally can't be here, but I'm going to see her this afternoon. I want to play it back. And the judge has discretion there versus a victim who says, every time I'm in a proceeding, this guy posts a YouTube video and puts my home address out there, and I've had YouTube take it down 4 times. Completely different situation.
Indeed. Good point.
Okay, so moving forward to subpart C. This was revised to remove reference to paragraph H. Paragraph H, again, that referred to the personal audio recording device, which work group is proposing to be removed from the rules. So that was removed. The reference to that was removed from subsection C. And again, all recording devices can be treated the same. Cover in this rule was replaced with user recording device for purposes previously discussed. C1 is the requirements for the submission of the request. Again, just a sort of a technical change again in C1, placing the term cover with a recording device. Subpart 2, this changes and expands the timeframes for submission of a request. The work group felt like the current timeframes are too short for the judge's full consideration of the issues and preparation of the findings of fact. So subpart A changed, if the proceeding is a trial, it expands the requirement to submit a request from 7 calendar days before a court hearing to 7 court days before a proceeding. It's not a trial. Subpart B changes the time frame from 48 hours before the court date to 5 court days before the proceeding. Subpart C requires that if the court schedules any proceeding on not less than 7 days notice rather than 72 hours notice, the person must submit a request as soon as reasonably possible. This also changes in subpart C, the term file to submit, because these requests typically won't be filed, they'll be submitted to the court. Any,
I had a question. What was the idea behind having a longer time frame and a request?
so the work group members indicated that the current time frame is too short.
48 hours right now, is that?
It's 48 hours on, if it's not a trial, 48 hours was too short if it's not a trial. So for any proceeding other than trials.
The problem with that is typically the press wants to record or go to the most exciting case, but you don't always know what that's going to be. So like if you have to make requests 5 days out, you know, if you have someone who's arrested for a really gruesome murder, and there's going to be a hearing and you just find out about it, you want to go to that one, even though you were going to go to another case. So I think it constrains the press a little bit. Reporting in cases if it's that long.
Well, and this may play into, I think it's subpart 3. 3, which now requires the court to specify a deadline for submitting an objection. So if the person's only required to give 48 hours notice, I'm not sure how the court can now specify a deadline for objection from parties or victims.
We have to do it quickly. I just think of a whole week before, again, it's just hard on the press. If something comes up, like, wow, we want to cover that. If you could have an election challenge, you know, those pop up very quickly. And the press could say, oh, you know, this in 2 days, we can't cover it now. Or we, as judges, we want the press covering proceedings because it informs the public about what we're doing.
So initial proceedings are within 24 hours. How would they do it?
Isn't that 2C? Isn't that?
2C, if the court
2C.
schedules any proceeding on less than 7 days court notice, a person must submit the request as soon as reasonably possible.
Okay.
So I think that would cover those examples, any sort of breaking news, IAs, things like that.
I was gonna say, have you thought about including a provision, like a catch-all that says that the court has the discretion to consider untimely requests? Like maybe to kind of address that media thing, like just to make it clear that even if someone were to submit a request not within the deadline, the court has discretion to consider it.
Yeah, I mean, I think it's contemplated in subpart 3 relating to denying untimely requests, but I don't know that the work group actually discussed creating a catch-all explicit provision, which may
Right,
not
so like
have been,
deny is one thing, but it
Yeah.
can potentially grant an untimely request within its discretion, because maybe that would give the judge some flexibility for things like Judge Metcalf. Right.
Yeah, that's a good point.
I think the court will probably always waive it for the press, and the time limit's really designed to prevent the person we saw in the video. It gives an easy out to say you didn't submit a timely request. So end of story.
And I'm slow to the gun, but in the definition of recording device, you moved away from sound or image, that kind of like, to orally, which is what I struggle with, visually or otherwise record. And I'd ask you just to think about whether sound instead of orally might work better. When you're dealing with somebody like this court security officer who we saw the video of, just a suggestion.
Sound images and video.
Yeah, you know, admittedly, I think most work group members find that there's probably a better term than orally.
You're on it then. Thank you.
Maria, while we're on 3, just had a question in the interplay between 3 and 5 when it comes to providing notice to victim or victim's counsel. It's currently, in request is not a pleading, but if victim's counsel has filed a notice of appearance, there's a general requirement that they're supposed to be provided with a copy of any pleading. I'm wondering if in 3, if you have a victim who is represented by counsel, if they're included among those that the court notifies. And then in 5, then the only individuals that a prosecutor would have to provide notice to would be unrepresented victims. And that would kind of flow with what we currently require. So that would also be consistent then with Rule of Criminal Procedure 1.7V and ARS 13-4437D. The distinction again would be at C3, if a victim is represented by counsel who filed a notice of appearance, then they would be included among the parties who get notice from the court. And if they're not represented in 5, that's who the prosecutor would be required to provide notice to.
Jose,
Would it be okay to go back to C1?
ready for one?
So just the second sentence there, and I've got John Rogers' admonitions running through my head, but it seems to me it could be much simpler. Two ways. One is would track the language here, and it could say a person who submits a request to use a recording device does not become a party to the case. A simpler one would be, or something like submitting a request does not make that person a party to the case. Something simpler than repeating the language about a request to use a recording device, which is what we're talking about here. And then throwing in words like standing, which the lay person may not understand what that means. Just a suggestion that I think would make John Rogers happy. That's it.
That's the goal.
This was the area that I was suggesting that we require the requestant to tell us what type of recording they're going.
Would you also want to know the purpose?
Yes, I think that's great.
Although I think there might be a First Amendment issue with purpose, because, you know, these are open proceedings to the public. You don't have to have a purpose. You don't have to, like for public records requests, you don't have to say to the agency why you're these records, because they're public, they're open to everybody.
So don't you have to indicate whether or not if it's for pecuniary interest?
Commercial
Yes. So there is some specification required.
Maybe say just like the nature of the purpose to just to include that they have to certify it's a non-commercial purpose, something like that.
Well, I think it would benefit a judge to know, because if the person says, you know, I want to use my iPhone to record, and I want to be able to post it to my website because we're running a court watch program. Okay, now you know. And if it happens to be a trial, well, all right, that's fine. But here's some additional limitations in. You may not record a jury. Witness objects, and we're going to have to review whether or not you can record that too. If you don't know the purpose of it, you may not necessarily know the additional reasons or additional information you want. If you don't put that they have to provide the reason in there, you're going to have the guy saying, I don't have to tell you.
Well, but they don't have to tell us. I mean, that's where I think we run into the First Amendment issue. I think we do have to certify non-commercial purpose. And would I like to know that? Yes. But I don't know that I need to know that for the purposes of granting or monitoring the request. And I do understand, I'm sorry, you wrote your name very small on top of David.
Matthew.
Thank you, Matthew's concern about First Amendment issues. And then also if they do disclose this purpose and say it is for a court watch and I deny it, then I run into a potential bias issue. They say, well, she just denied it because she didn't want me to run my court watch site. Whereas if I don't know, other than non-commercial purpose, I feel like I avoid a bias accusation. I can say, look, I didn't know why you wanted this. I denied it because you didn't, it was untimely. And I exercised my discretion to not allow an untimely request or something like that. Or because I have concerns about your behavior because you've acted inappropriately in the past. Again, it's not a purpose issue. It's because of the behavior that you've had in my courtroom. And I think that helps me avoid that.
But you're not the only person that has,
I think we always appreciate a good record.
But you're not the only person that has a right to know the request. And so I think having a party clearly define what it is they're requesting, the type of device they're going to use, and why they're using the device, gives the other parties to the litigation at least an ability to determine whether or not they're going to object. I mean, just because it might make your ruling a little bit more mucky, I don't think is a reason not to require it.
I'm always concerned about amendment issues though. Again, I guess I'm not sure where the other person has that right, you know, the victim or the prosecutor or defense attorney has that right to know. Like,
Well,
where does that
the
come
victim
from?
has the constitutional right to be free from intimidation, harassment, or abuse, and to be treated with fairness, respect, and dignity.
Yeah.
This certainly falls within that, and our case law supports it.
So the victim, and I guess not the prosecutor, not the defense counsel, not the defendant, the victim alone has the right to know this.
Oh, yes.
Well, I'm saying the victim alone and not anybody else is that what you're saying?
Oh, well, in addition to others,
Okay, but
certainly in the first instance.
where does that come? So we don't only have victim cases, there's family cases, civil cases, things like that. Where does this right come from other than arguably the victim's bill of rights?
Well, that's a constitutional right, so it's pretty strong for the victim there.
Absolutely.
With respect to others, well, we don't know. We don't know what the particular circumstances might be. And you wouldn't know if nobody was aware of how it might be used to be able to raise the issue.
I think the concern about victims is covered later on in the rule where it says that a victim or witness can object at any time. So if they see somebody come in who they know is going to harass them or, you know, is for whatever reason they don't want them recording, they can object immediately and the court will deal with it at that point. I do think that there is a strong First Amendment argument that requiring someone to state a purpose for recording a open public court proceeding would be a violation of the First Amendment. You could, I would take a case saying that this court denied me my First Amendment right to broadcast or transmit information about a public court hearing because they didn't like the content, because they didn't like my political point of view, for example. And I think, requiring to state a purpose is just kind of asking for that kind of trouble.
Thank you for your input on that. We'll take that out.
Okay, so we are on. Step C2, the summary there. C3 is the court action upon receiving a request. So again, that's going to be the requirement to notify the parties. See some comment on that, expanding that notice. And then I alluded to before, the court's notice must specify a deadline for submitting an objection. That is new. And then the last sentence there, the judge may deny an untimely request without that hearing. That again is new. That just provides clarification there.
On that C3 section of first sentence, so two different thoughts here. The first sentence, court must notify the parties. We add in writing before the pending proceedings. Sometimes we run into the judicial assistant makes a phone call and then you're missing some documentation if something comes up. An email, I think, would work for that. But sometimes those phone calls are where things get lost. And in the last sentence, possibly something going back to the discussion we just had, if that said the judge may approve or deny an untimely request, that might address those last minute media.
I just wanted to make sure, and it sounds like we did get it in there, that somewhere in between B and C or after C, there would be that exception that it's within the judge's discretion to grant a request sort of, I shouldn't say at any time, but for the cases that a trial could have been scheduled, media not necessarily interested in it, but some new development has occurred that's extremely, perhaps newsworthy, but the trial starts tomorrow, that they could still submit a request, whether or not it's granted or not.
Yep, I have that marked down. We have that noted.
Okay.
Yep.
Did you consider requesting or requiring a form be filled out or have a form with all of these check marks? Because now we've heard commercial, all of those things, and a lot of other areas, there's just a form. You look at a form, you fill it out. That way everybody gets the same amount of information. The same style request goes to the judge. So have you considered drafting a form that would go with this?
Work group did not discuss that, no. But a lot of these things have just come up, you know, these considerations today, but the work group did not talk about that before. I think we were gonna suggest leaving it to the local courts because presumably they already have these forms in place, right? For people who are presumably they don't
have a form.
Yeah, so
We have a media person, that's her job to handle all this. And all the reporters stuff know how to do all this, or even members of the public on our website would tell them where to go.
So, we didn't, so yes, to answer your question, no, we did not, think about drafting a standalone form. Okay, number 4, C4, time for a party to object to a request. So, this separates out family law and protective order proceedings from every other type of proceeding that, it would make family law and protective order proceedings a provision that the parties can object at any time as opposed to being limited by the deadline set by the court. In every other proceeding under B, person would waive the time of objection if they didn't object by the timeline set by the court as provided in C3. The form of objection, so you see, it's got to be in writing or on the record. Yep.
Sure. It's a general comment about the phrase or the word proceeding. In C, I mean, it can be the thing, the case, or it can be the specific hearing, right? And I think if clarity could be added kind of in this chunk of this rule, that would be helpful. For example, C2A uses the phrase specific proceeding, but C2B doesn't. And I think when you use, I could see a world where proceeding would mean the case broadly, like it is listed in 4A, the family law proceeding. Specific proceeding could be the proceeding that the party wants to record. Does that make sense?
Yeah.
And I don't know what the best resolution of that is, but it just seemed if proceeding and the thing to be recorded could be differentiated, and then to use the thing to be recorded kind of consistently throughout.
Does the definition of proceeding change that at all? Or do you still have the same comment?
And it might, but then I think C2A needs to be changed because you've retained specific proceeding there, right? And then maybe clarity in 4A about family law, party in a family law. I don't know if it's a case, but proceeding then is plunked back in there. And protective order proceeding as well. There's a way through it, I'm confident. It's just a little tiny stumble.
Maybe matter rather than proceeding.
Could be, yeah. I mean, there are a bunch of different ways through it, but.
Well, we're ready onto this, the way it's drafted now, you were limited jurisdiction for it. 25 traffic ticket cases coming up, and they wanted to record, but it's a ask for each one individual. Or 100 evictions, or you change, even Superior Court change a plea, you might have 50 on motion day. Is that how we contemplate? They'd have to request each one individually?
Yeah, I think so. I mean, that seems sort of burdensome, but that would be the policy today, however they're handling it today, the revised rule wouldn't change that. So I don't know, on these cattle calls.
It is case specific, the request is.
It is every.
And so typically, let's say a high profile case, the guy will just sit there with his camera. When they call that case, they turn it on and they record, but not recording the whole time on the other, on a cattle call.
Yeah, so it would be for each one.
The reason I ask is some of these folks, they're First Amendment auditors, and they're not really interested in individual case. They're interested in the judge. the proceedings. If they're gonna come in and they want to record the morning calendar to show how the court's functioning. So this might be a deterrent if you gotta do it every single case. That's what they're doing. They're using them for influencers and, media content, not so much the high profile cases they want.
Is there any reason why in a juvenile isn't included? And I don't mean for delinquency, but I think the rules are different for when it's termination right now, as far as what can happen and who can do what, but pre-termination, so like dependency. And maybe it's that you selected family and protective order because those are more litigants, and in juvenile, there's gonna be attorneys. I just was curious as to why juvenile party couldn't object.
Dependency proceedings are not open.
I thought I thought it wasn't until,
Delinquencies are.
but I thought there was, looking at the rule, here it says under 825, court hearings concerning dependents are open to the public. It says concerning dependent children, permanent guardianships, and termination of parental rights are open to the public, except as otherwise provided in 8537. And 8537 is just termination of parental rights. I thought you had the discretion to close the courtroom, but it wasn't automatic.
That's right. The dependency proceedings were changed a number of years ago, so the judge can close them. Somebody has to object even on the dependency.
That was just something I was bringing. I'm not saying I think it should be, but just didn't know if it should be included in that.
So under L5, there's a juvenile, recording of juvenile proceedings in general are prohibited altogether. Unless there's an exception, unless otherwise allowed by law, right? So that's sort of a, if it can be recorded, it would be permitted unless it's prohibited, right? So, number C4 talks about the objection timeframe. So it may be something that the work group wants to go back and look at to see if there ever is a scenario where somebody would be permitted to report a juvenile proceeding and whether there should be an objection timeframe for that. That's what that's going to. So
Can I have that just, when we go higher, what's the citation for this? Just the numbers, so I'm trying to get piece instructions.
C.
Thank you. C4. Thank you. That's all. I was just getting a little lost. Thank you.
Yep, that's C4.
Okay, thank you.
Any other comments on C4 before I move on? No. Right, so C5 talks about the time frame for objection for victims or witnesses. That leaves much of the current rule unchanged. It adds in there that any objection must be in writing or on the record, which brings that consistent with 4C. It also allows the prosecutor to submit an objection on behalf of the victim.
This where Justice Montgomery was interested in being able to put in something for the victim's attorney.
But it was just in conjunction with C3.
Okay.
C5, the only victims that the prosecutor would be required to provide this to would be unrepresented.
Yep.
They expect their counsel to file an objection.
And moving on to D, denial or limitation of a request, again, replacing coverage with request. It removes the first portion of that sentence related to presumption that the request should be approved. It just sort of leaves it to the court. The judge will make an individualized determination after considering the enumerated factors, which we will get to next. And then it, like I said, it replaces cover and coverage with use of a recording device or. So moving on to.
Question on that, sub B, that last sentence as proposed, a judge's decision on a request for order proceeding. That be record or broadcast, transmit, whichever word it is. Sometimes the phrasing is use a recording device. Here it specifically says record. So it might need to add or broadcast, transmit, whichever. phrasing.
Use a recording device, however, we end up defining that, if we added live streaming or broadcasting, what have you, that would cover that. Something else for that work group to consider. Moving on to D1. The first paragraph there, a lot of that is largely stylistic. And the only factors that were changed in this substantively were G and H. I'll take H first because it's, in my opinion, it's a little bit simpler. It just adds any other factor affecting the administration of justice or court security. So we added court security there, and these are going to be factors as to why the court might decide to deny a request for coverage. Not using coverage anymore.
Before we go any further, we have a question from Michael Moran.
Yep.
So my question is on the subsection D, why reviewable only by special action? And what does that mean? Appellate special action or to the very judge that decided it? I guess one concern would be if there is a First Amendment issue that the denial was content-based or viewpoint-based, and then they don't have an ability to bring a federal constitutional claim by right. Appellate special actions are discretionary. And so I'm worried about some sort of procedure that would discriminate against federal constitutional claims and not allow something like that to be brought in court by right.
Yeah, so that's a provision that's retained from current rule that carries over. The work group did not discuss whether that should be clarified. But I suppose it's something that they could discuss. But that wasn't heavily discussed by the work group as far as review goes.
And because I'm a fan of the Arizona flag. Because I'm a fan of the Arizona Constitution, I'd also say you might have a claim under Article 2, Section 6. So not everything has to go to the federal Constitution. Just saying.
Also, there's an abstention doctrine, I believe, that you can't go to federal court to appeal something that happens in state court. Everybody remembers federal courts from law school or whatever that is.
It's just a concern would be that if there really is an issue on a denial, that you wouldn't want to make it a discretionary review process, which is my conception of special action. I understand that it's a carryover from the previous rule. It's just, I think it's something to think about here.
I guess the concern is special action is the only way to really get some timely review of something like that and get the issue cured.
Yeah, or maybe just specify pursuant to the rules of special action.
Yeah.
But what would prevent just filing a normal case in Superior Court under the state and federal Constitution?
Like a civil suit?
Yeah, civil suit, just to clarify the law going forward, that how judges should and shouldn't be making these decisions, not necessarily to get an emergency order to permit you to go into the hearing, but after the fact, I was denied this, we can't remedy that, but I think it's important to, just to develop the law. Why couldn't you just file a normal case in the Superior Court?
A declaratory action request? I'm just a little confused about what that might look like.
Yeah, I'm not sure if I know exactly either. I guess Just something to flag, just a concern of by special action and not allowing someone by right to bring that claim if it's discretionary.
Okay, thank you, Michael. We'll look into that.
Okay, the larger change to D1 is G. It strikes the text to a broad community. And the work group members discussed this somewhat at length and thought that the text to a broad community may be too rigid. And so by striking it, it creates some flexibility. And it would just essentially leave the factor as whether the person making the request is engaged in the dissemination of news, as far as, factor that might tip in the balance of denying the request. Any minutes on that?
Just in terms of scheduling, Rita, we trying to keep this to about an hour. I think we should press forward, perhaps over the next 20 minutes, everyone to try to get, the most insightful criticisms or concerns about what's left. I think we're getting there, but the objective is to try to get feedbacks on all of these revisions so we can return with a draft petition next meeting. So we'll pass it ahead.
Justice,
Yes.
I want to go back and just put something on the plate about the commercial purpose. I don't understand all the revenue models of how people make money off of websites and that sort of thing. So if there is any interest, in adding that, a vow about commercial purpose, that may be something to look into, whether the definition of commercial purpose under the public records law works. Because if somebody's uploading video on some website that they can recover, that they can get money from, that might go into the definition of, that actually might fall under the definition of commercial purpose. So if there's any interest in adding that in to that disclosure to the judge.
I would encourage you all to think about that, because there are a lot of instances where someone is intending to be a disruptor for pecuniary gain from their websites, and they intentionally manipulate and alter the intention of the context of the hearing in the first place.
But I think the use of commercial purpose under public records is because the government agency incurs costs in producing the records, and if they're going to make money on them, you can charge them more. So I don't know that really applies in the context where you're just recording your own expense. So, and everybody, I have no idea how influencers make money either, but probably everybody in there who's using it is potentially making money, and that's generally not going to be.
Thank you. Moving on to D2, there is not a lot of substantive changes here. Changes to 2A were mostly stylistic. 2B, we added video broadcasting. I will take note that broadcasting is somewhat limited there, so the worker probably needs to revisit that. 2C, we added in party and victim, so then now prohibiting the coverage of the testimony that a party, victim, or witness would have a substantial impact on that person's testimony. So they're going to be limiting coverage there. Subsection, there's a new subsection 3, D3, added to clarify that the provisions of this section do not limit a court from reporting or publicly broadcasting a proceeding on its own initiative.
Doug Metcalf.
Subsection E, manner of coverage was changed to conduct. The, most of the front part of that rule was relocated to the new subsection F. And therefore, this just retains what was previously there, relating to persons engaged in coverage must avoid conduct or dress that disrupts the courtroom or proceedings. And then it retains the provision relating to that the court can order restriction or cessation of coverage that's in a courtroom or during a virtual proceeding, to clarify and make that distinction there. And further of the interest of justice. That's bolded, but that is what's in current rule today, notwithstanding the underlying portion. Any questions about that? Subsection F, there's a lot of strike through, a lot of underline there, but it essentially keeps the substance of what was previously in F and E. It sort of combines it and generalizes it, takes out specific references to light bulbs, microphones, strobes. And then it just generally says, not to use anything that produces distracting sounds or otherwise disrupts the proceedings. Any question about F? Then the number of recording devices. This again was related to the large media coverage, and so the work group tried to restyle this so it would apply to just generally everybody. The first sentence was removed as somewhat unnecessary. And then the other provisions of this were just generally restyled. There's not really any substantive changes to this provision that would impact recording in the courtroom. Subsection H, that was deleted in its entirety. That's the provision related to audio recording devices. The new subsection H it adds a sanctions provision. So it clarifies that unauthorized use of a recording device in the courtroom without the judge's permission is sanctionable, including, it gives some examples, including but not limited to contempt of court or criminal charges. Somewhat mirrors other rule provisions that provide for sanctions. It's nothing new there, but that is a new subpart. Subsection I, nothing substantive there, just some restyling provisions. Subsection J, there were no changes. Subsection L, this was previously no juvenile proceedings. It was expanded to prohibited proceedings to include mental health proceedings and any portion of a proceeding involving a child witness. Creates prohibition in those cases in addition to juvenile proceedings unless otherwise allowed by law. Number 6 in your packet, that again is a restriction or cessation of coverage, and admittedly that duplicates what I just talked about in the existing rule. So the work group does need to go back and look at that. So at least for now, you can sort of ignore that. It just pulls over similar language. So at the end of the day, it will probably end up in one section or the other. Lastly, the governing law. So really no substantive changes there, just rewording to make it clearer on the first sentence, which previously provided a person whose request under paragraph C has been approved to photograph, record, or broadcast from is still subject to Rule 122.1. The work group felt like that didn't really convey what it was probably intended to convey, so they reworded it to hopefully clarify that even if a person is approved to use a recording device in a courtroom, they're still subject to Rule 122 relating to recording in the courthouse and any other administrative order that would be in place. Okay, any last questions? That's the last question. Is that cool?
I wonder on paragraph H for unauthorized use, should we consider as an additional sentence in referral to the state bar? Apply to lawyers doing an unauthorized recording?
You know, the including language, so that the work group, they don't want to get too specific, recognizing that including, you know, anything that follows isn't an exhaustive list. But the purpose of including contempt or criminal charges there was really to put people, the public on notice that these are the potential consequences. So I don't know that they considered referral to the state bar. That is obviously something that's possible, but I don't know that they want to get into every single thing there. Something for them to consider.
What criminal charges could you face or could a person face?
That would be interference with judicial proceedings under 132810. That's the ones that they were considering there.
I know that we have talked about, you know, these are public proceedings, so people have a right to be there, but it seems like with age, there may be an opportunity to clarify the ability to broadcast and alter and manipulate the proceedings and potentially mislead a viewer. That might be, maybe the task force disagrees, but it seems like we have discussed that one of the common misuses outside of trying to harass a victim or a witness is also to mislead others as to what is actually going on in the courtroom. And it doesn't seem like the rule has anything with regards to that being something that we weren't intending to give somebody unfettered ability to manipulate the images in the courtroom, for lack of a better way of saying it. I don't know if H would be a place or whether it's something that, I mean, I recognize that somebody discussed the lack of the ability to really enforce, but this is the one section where I think we're trying to give the ability to enforce.
Once it's out, there's a First Amendment right, and you have no control over it. I think people can do whatever they want, manipulate it and do whatever they want. I don't think there's any limits on that.
Well, 2810 actually says that if it's a crime to publish a false or grossly inaccurate report of a court proceeding. I didn't know that. I was reading the statute. Then asked about it.
That's statute. I do any concern. But yeah.
We tried to not skate out onto thin, huge ice in terms of that, and then get into the realm of attempting to define what misinformation is or misrepresentation is. I take your point, and that is a concern, and I think it could easily fit within the definition of harassment too. If someone is mischaracterizing what's happening and inviting the public to take specific action against a particular judge, I think it fits a broad definition of harassment. But we did talk about this, and a number of times we decided to remain safely on the away from the free speech line in terms of crafting the rules and revising the rules. Jose.
Yes, another word nerd comment. Just pointing out that in other parts of the rules we've dropped, but not limited to as redundant.
Yeah, I think there's one place that talks about that, and that's going to be in the definition of recording device. Is that where you're seeing it?
Yeah, H, paragraph H.
Oh, in paragraph H. Yeah, so where that was, it's also added in the proposed definition of recording device. And that was very, very intentional in the context of this rule to put people on notice that this rule is not exhaustive, to make that explicitly clear. So it was intentional here. The work group did go back and add that phrase in, recognizing that it's not consistent with the way wording in some of their rules is.
John's not going to be happy. That's all I have, Your Honor.
Just real quick on K1. Was the intent to allow recording even when the court is still on the bench but off the record? And if so, what's the reason for that? Couldn't a judge restrict that as well?
On K1, so where we added in, or the court is not in session.
Because I think there's a difference between being on the record or you could still be in session on your morning calendar, right? And just not on the record in a particular case. Maybe I'm just being too technical.
No, it really had nothing to do with being on the record. It was so that if the court finished the calendar, that the judge remained on the bench, that the person not record. Yeah, so essentially only when court is in session may the judge or may the person record.
So if the judge is just sitting there between cases, is person going to sit there recording him or her?
Yeah, that would be great.
Yeah.
Yeah,
I just wanted to
the
flag that,
intent
yeah.
was to not allow recording during that because the proceeding is not underway.
Okay, I
Absent the courts of approval,
Yeah.
I suppose. I mean, suppose the court could approve recording during that, but that would not be recording a proceeding.
Okay, so the definition of proceeding, I guess. Okay, thanks.
I just noticed in a couple of places the word coverage is still used, and I was wondering, is the task force gonna go back and clean all of those up?
Yeah, there's about 5 or 6 places where it's still in there, and that will be taken out. Presumption is that the rule will no longer refer to cover or coverage at all. That'll be cleaned up.
All right, well, unless there's anything else, thank you all for your very valuable insight. And so this will give us something to do to clean up the revisions and hopefully have a petition that is in final form when it's represented on December 9th. So I think we're just barely over our allotted 1 hour time to present a work group presentation. So that moves us to item number 4, and we'll continue the work group presentations. We have, in addition to what was just presented on Rule 1.2, we have 17 rules on the agenda today. 9 of those, however, are carryovers from the last meeting. Our intent is to allot each work group about an hour. I think we still have plenty of time to do that. In the future, we're going to mix up the order of presentation, but for a number of reasons, today it makes most sense to continue in numerical order, beginning with work group 1. So we'll go 1 through 4. But next time, I promise Justice Montgomery will do our best to begin with work group 4. So not to give them short shrift. And also with respect to work, to add insult to injury, Justice Montgomery graciously agreed to put the trust accounts presentation on hold until the next meeting. So,
sorry if that disappoints anybody.
but we reached mutual agreement on that. And so you'll have a month and a half to prepare. To lead the group off with that next time. So with that, where are we at with lunch? Do we know when we expect one? Okay, perfect. Okay. Well, then let's not waste any time, and we'll begin with work group 1. Judge Coleman, are you going to start us off?
Yes, and Rule 27 should be a little light on discussion, conceivably. A lot of the changes we've made to Rule 27 were meant to be very much just working with the style guide and not make any major changes. So number 1, so looking 27A1, again, we just tried to remove, may be commands. We removed, passive voice. We tried to add some substructure. moving through it, relatively quickly. How the certified questions come about, filing the certification order with the Supreme Court clerk. We removed some substructure about the clerk and just put it right back up into one, just again, make it a little leaner. We did want to define what the certification order must state. So for the questions of law, statement of facts, the parties, lawyers, we did add in mailing addresses and email addresses to make it clear that both should be included. Indications about filing fees and any other relevant matters, which we shortened greatly from any other matters that the certifying court deems relevant to this court's determination of the certified questions certified, or of the questions certified. So again, we're just trying to make this a bit brisker and clearer. Does anybody have any questions about A1 and 2? Good, glad we can make this nice and breezy. Let's go down to A3 and what kind of additional record that the court may deem necessary. Again, just trying to make the wording less passive, remove unnecessary verbiage and things of that sort. Anybody have anything on A3? B. Trying to draw the timeline, as good rules of procedure might do, and discuss entering the order, accepting jurisdiction or declining jurisdiction. I'm sorry, Doug and Sam are in the work group, and I'm moving too fast. Am I missing anything?
No. We're just talking about a hypothetical.
Okay. As far as working through the process, accepting or declining jurisdiction, transmitting the order. And we did put that no one may file a motion for reconsideration. That's already in the rule. Again, we just wanted to make it nice and clear. A lot of this involved things like adding in these subject lines in bold to draw the eye and attention, and adding that substructure again to draw attention and make it more clear. You guys have anything to add? I didn't need to move on without you.
You're doing great.
We asked him to share it with the whole class, or?
No, but it did make me concerned, especially because I'm gonna be.
So I'll tell you real quick. We were talking about, is there ever an instance where the federal court doesn't ask for a certified question, where they go off on their own and interpret Arizona law? That was kind of hard.
I'd be really interested to know.
I don't know the answer to that, but
The answer is yes.
Yeah.
Yeah, and then they regret it because the Supreme Court rules the other way.
Last words.
And then C, again, just to simplify it, filing fees. And remember, we talked about already above about proportion of filing fees, but also, of course, we must let them know what the filing fees are and when they must be paid. Anybody have anything on B or C?
There's just a question on B3, motion for reconsideration. I like that this is a short, single sentence. No one may file a motion for reconsideration in order declining to accept jurisdiction. In civil appellate rules, 22F, there's a section on that, but it's phrased unless permitted by specific court order, no party may file a motion for reconsideration. That make a difference.
It wasn't in the original rule. But that doesn't mean that it shouldn't be considered if we might think that it might be appropriate. Is there a reason why we should put in the court's ability to permit a motion for reconsideration? Does anybody have any thoughts on that?
Maybe we want to keep that flexibility. Something could happen in the interim.
Well, the Supreme Court always has the ability to waive its own rule.
That's
Sure.
So it doesn't, whereas the civil appellate applies to the Court of Appeals too, so the direction's a little broader.
Although I guess the only thing where that might, we wouldn't know we'd want to waive the rule after we declined jurisdiction if something happened that we weren't made aware of.
So how is it phrased in the civil appellate rules? I assume somebody would need to file a motion to request the authorization to file a motion for reconsideration. Does it lay all that out, or does it just say unless authorized by? I just don't have it off the top.
There's an introductory clause.
Right, unless permitted by specific court order.
Okay.
No party may file a motion for reconsideration.
I don't think that would obtain here, would it? Because the court's denying the request for certification. And I'm guessing they wouldn't say, but if you want to file a motion to reconsider this order, you can do so. You know what I mean? If we include that concept here, I think we ought to include it as a rule as opposed to picking out to the order. Does that make sense?
I mean, the way I've sort of seen a motion for reconsideration where otherwise not authorized would be filing a motion requesting permission and including a copy of what that motion would be and bring it to our attention.
Thoughts? Do people think we should put that phrasing in here? I do like the idea of unless authorized by specific court order without, you know, having all the verbiage of how you would go about it. Thoughts, anybody? We're gonna have Veronica add that as a potential.
I have one thought. Yeah. Do we want to make a distinction between saying you cannot file the motion versus the court will not consider the motion? You see what I'm saying? Like if we're opening the door to say there are some.
Unless authorized by specific, well, but then.
Or do you want to keep it to no one may file? Like they can't even file a motion unless the court authorizes.
I just feel like we're just already thrown out with the barn doors.
Okay.
That doesn't mean that I'm not open to the idea. It's gonna be kind of a clunky way to word it. Unless.
And I don't think we've denied maybe only one time in 6 years. We denied certified questions.
Just something.
I don't know, that there's my initial thought.
Okay. I withdraw my comment.
Veronica, can we add that potential wording? Unless authorized by specific court order, no one may file a motion for reconsideration? Yep. Sorry. Sure, unless authorized by specific court order, comma, and then just make n lowercase. Is that consistent with what we're thinking, Aaron?
It is.
Okay. All right, anybody have any other thoughts on the remainder of B and C? Okay. D, with the substructure, was laying out the process for briefing and for argument. Again, trying to make it, trying to fold in some clarity while also leaving some time, some authorization open for the court to extend deadlines, to order oral argument or not. And anybody have any thoughts on D1 and 2? All right, let's go to E and F, and we're almost done. See, I was hoping this would be nice and breezy, so we can hopefully make time for everybody else's as well. So we did state that the court will not award costs or attorney's fees. And we actually did remove the apostrophe S. We did just make it attorney fees. One thing that actually I didn't think about in the work group, but maybe we should discuss. I know that with the advancement of legal paraprofessionals, and I know that at this point, I don't think that they would be authorized to work on a case like this based on our rules. But should we just say something like legal fees, no costs or no legal costs or fees, to allow not having a concern about whether counsel is required in the future? That's my only thought that just occurred to me, and I did not bring this up in work group. Did we talk about this in work group? I don't think so.
If we were going to expand so that they could do Supreme Court proceedings, wouldn't they have to amend various rules to allow for that? I mean, to be amended then if it was expanded then?
We could do that. I just kind of gotten used to the shorthand because they appear in family court so often. So nowadays I just say legal fees and costs. So
Attorney's fees is a term of art.
sure. Yeah, we could keep it. That's fine. What do people think of those as far as the wording as it is without me trying to throw a wrench in here of E? Anybody have any concern? This is also already in the rules, so we just restyle the wording. It's not a substantive change.
What's the purpose of the change?
We just restyled the wording.
Right.
Yeah. So it was already in there. It's not a substantive change. It was very wordy to begin with. It said that something like there shall be no application for costs or attorney's fees made to the court in connection with a certification proceeding. And so we just wanted to simple it up.
Like passive voice, affirmative normalization.
Exactly. It's everything Brian Garner told us not to do. So, yeah, so we just, John, I think was the one who took the swing at that one. And then finally, the RCAP applying. We did want to discuss whether we are going to add this to Rule 1. And if we add it to Rule 1, then maybe we don't need to have it here, but we also know that's probably a decision we're going to make on another day that's not today. So we want to just leave a flag. Thoughts?
And I should note, as we presented Rule 1, the prior meeting, it does incorporate that rule for motion and incorporates RCAP.
But we didn't know if you would want to keep it there. We do think it needs to be somewhere. So we can always cut it if we keep it in Rule 1. Okay. All right, that's it for Rule 27. John has Rule 28.
Yeah, Rule 28, that's in page 58 of your materials, the red line version. Rule 28 was adopted back in 1988. It's last revised in 2018. Most of the changes that are shown here are simply restyling. And since the rule is relatively recent, it didn't require a lot of restyling. There are 9 items that you should note, though, where we did tweak the rule and made some substantive changes. First on A3B, we did have the prior rule saying if you were filing a rule petition in paper, you also need to submit a Word version on a CD and submit that to the court. But we needed that because the staff attorneys and the court need to prepare orders. And so we, rather than make this type over everything, retype everything, we asked for that. We were instructed by AOC that we couldn't ask for CD anymore. So instead, they came up with the suggested alternative, which is to create a link and the frequently answered questions portion of the court forum. And that way they can upload a Word version of their petition if possible. The other thing we try to make it very clear that it's not mandatory. We're not going to reject a filing to give us a Word version. So it says in here it's only if possible. And we do try to direct the reader to go look at the frequently asked questions in the rules form. Yes. I just have a question about number 1 says petitions amend abrogated court rule with statewide applications. Aren't all the Supreme Court rules statewide application? Why do you have to say that? I mean, it's in the existing rule. It's A1, 28A1 petitions. Any person may petition this court to adopt, amend, or abrogated court rule with statewide application. Why do you need to say with? Since they're trying to distinguish, if you're trying to change a local rule, you've got to go through a different procedure. Well, this is not the rule you look for changes to local rules. You look for 28.1. Does the Supreme Court ultimately on a local rule? Ultimately, the Supreme Court is the one that decides to approve or reject local rules. It's different procedures. Well, then I think it should say with statewide. Second change was A5. There was a provision in the prior rule that had kind of a pre-screening mechanism for the court to use when a petition is filed. If the court said, well, we really don't want to, we shouldn't be going here, we should have a special committee. I think it's kind of a dead letter. It never was implemented. Generally, the court, when it makes a decision to refer something to a committee or task force, it's only after it considers it during the rules adjournment. So we eliminated that requirement. Back for a question here. Rule 28A3.
Back to electronic filing. Had a suggestion on restyling for that one. I think that's what Veronica has up on the screen now. I sent it ahead of time because I thought it'd be a little clunky to try to read here. But I tried to get rid of constitutes and some long phrasing. So an electronically filed petition is the original document under this rule. Cut out a bunch of words. Petitioner will only receive documents electronically from the court and from those filing comments on the petition.
That's much cleaner. I think it's an improvement.
And then I have a similar change when you get to 28E3A1.
E1.
E3A.
Okay, before you get to that, if you look at E2, one of the, we have one in the rule that any time comments. The rule itself said you have to file comments by a certain date. Clerk, this is with people need an extension. You have to talk to that one. You had 3A.
Yeah, we'll cover that when we get back. I took you off track.
And Aaron, your comment was on E3A3. 3A1. Let's straighten.
Yeah, Veronica has that one on the screen. But any person would say anyone filing electronically will only receive documents electronically from the similar phrasing to the one I just.
I think it's cleaner. Go down E3A3. This is really intended to kind of clarify the practice about how you can submit comments. You have two options. You can submit a document, as a lot of people do, but there's also an alternative that is available for you just to type in your comment. Let's try some describe and stand. And E5. Again, it's if I to take into account big file replies, and also allow when you give an extension of time to file a comment, instead of having an automatic 14 days, just do a reply and to say that the court order will reply. Because sometimes it's the time in advance of the rules agenda isn't sufficient to permit a 14-day reply period. So sometimes it's reduced only to 7 days. In F, F1, there was a provision that was put in the last set of rules to take into account we had instances in which people were lobbying, having meetings, and the court felt comfortable having that done. So they wanted to provide a provision saying that you can put whatever you told us on the website or direct you to submit a written comment. The committee decided to take that out because it's simply never been used. So it's kind of a dead letter. Seventh change on G1. Wanted to take into account the report not only has August rules agenda, but it also has a December rules agenda, which is usually used to kind of clean up what's left over from the August agenda. And here too, an eighth change in that same provision. In case the court may decide after considering a rule petition to refer it to a committee commission task for further study. And that just reflects the present practice. Ninth, something changes down in H2. Just to clarify that when something is adopted on an emergency basis, it must be open for public comment before the rules are adopted permanently. So make clear that you don't necessarily get public comment in advance of the advanced adoption. I had two other picky points which I had missed in earlier drafts. In G3, I missed Oxford comma. It should say petitioner, persons, comma, and organizations. And I don't think Rob Trackers is wrong. It should be to 1C rather than 1B.
I do. Back to. Sub D, distribution of petitions and requests for public comment on page 60. So I was checking with this group if distribution could be changed to notification. That would bring the rule up to speed with current practice. So it's not that the clerk is sending individual emails to this long list of people who get that with attachments of all these things to it. We're basically sending notice in one blind copy email saying the following has been posted, and it has all those links to the materials. So the effect is that everybody who needs notice is getting it, but it's a notification as opposed to the phrasing on the rule here. At last sentence.
Well, I don't have a problem with that, but the clerk's gonna have to change his convention. We usually put when something's supposed to be Rule 28 distribution, it's listed that in the CC panel. So the convention has to change the Rule 28 notification.
I don't have, could we keep the phrase distribution and just clarify in the body that we're notifying, that we're distributing by providing links? That's a pretty common way to distribute material.
Yeah, so that's the other proposal, leaving distribution in that last sentence could be the clerk promptly notify the following of the posting. You lose the rest of that.
Can provide a link.
Notify the following of the.
Well, so this is why I don't know if we want to say notify of the posting, but say can distribute by providing notification with links or something like that. I just think that that's a little bit more clear, but it also means that the clerk's eye goes to distribution and obligations. So instead of just saying the following of a posting, just say must promptly notify the following of a posting and provide direct links or attachments. And that way they've got an option. Something like that. I think that gives the flexibility while still, because I do understand distribution is supposed to be a buzzword for the clerks.
So perhaps they notify of the posting, can provide a link or copy.
Yeah.
Of a petition.
While we're on that paragraph, the second to the last entity, Phoenix Association of Defense Counsel doesn't exist anymore. The Arizona Association of Defense Counsel. Our Tucson brothers and sisters got upset about that, so we changed it.
I'm sorry, what one is that?
Phoenix Association of Defense Counsel, second to the last, to bottom of page 60.
What is it? Is it called now?
Arizona Association.
Yeah, it's where it says executive director. It's up a few lines. There it is. Does it still have an executive director as its primary?
Yeah, they do.
Okay, so we would keep executive director and we would just call it the Arizona Association of Defense Counsel?
Yeah, be accurate.
Okay, so maybe yes, maybe no, sub G. In that annual rules agenda, the first sentence, it says in the same sentence, each year and annual. For John Rogers. If you are interested in that. They get rules agenda if you keep each year.
Makes sense to me.
Exciting subject, yeah. On rule 102.
Yeah, rule 102, public review of orders under ARS 36-2152, which is the criminal consent waiver proceedings for abortions. It implements that statute, ARS 36-2152. There has been these matters are resolved in Superior Court. There's been one appeal in Re BS, which was decided by the Arizona Court of Appeals in 2003, addressing the standard of review. And there's been some challenges that are not person specific over the statute, but that's the one challenge, one appeal that came, and that court said, hey, it's clear and convincing standard that's required. 102 was adopted in 1990 originally, was amended then in 07, 08, and most recently in 2015. And the Administrative Office of the Courts has a self-service center with forms and process to kind of describe how things ought to work. As you note in the red line, the current rule doesn't have titles. One of the things that this new, the proposed amendments add are titles for the rule. And then there was a question, although I think it absolutely still does have traction here, is given the change in recent law, both nationally and more recently in Arizona, whether the statutes have had an impact, perhaps, but the provision 36-2152 still remains. That statute, by the way, uses some terminology that is different than how ordinary litigation works. So that's why you see a petition for appellate review. It's filed differently. It's filed with the appellate court. These are very quick hitting, fast moving cases. So if you see some terminology in here that doesn't quite strike you as right, given your experience in other realms, you're probably right. But we've tracked the statute. A talks about the petition for appellate review, what needs to happen, where it's filed, with related changes, trying to sort of simplify and shorten the current rule, and also note that there are no filing fees in this. Happy to open this up for questions as we go along, but my thought is to kind of follow Amy's approach to tee it up. Yeah, Jessica.
I had a question for you. I know that the terminology is specialized and I don't have it off the top of my head, but if we're on the filing fees, should it, because we're including Superior Court and appellate, should it be the petitioner or the appellant? Because above you talk about the appellant.
Yep. No,
I don't mean to make it too wordy.
No, so it would be filing fees are not required of the petitioner in the Superior Court or the appellant at the appellate level, something like that. That makes sense. And feel free, other members of the work group, to kind of weigh in here as we go down this path. Other thoughts or questions on A? Let's then go to B. The record needs to move fast in these. And B kind of talks about transmission of the record and also adds what needs to be included, which is a certified transcript of the Superior Court proceedings. That's atypical in most appellate matters, but it's part of this rule here. John, you look like you were eager with the comment.
It's all the little picky things. I think there's appellant. Should I say appellant files the notice instead of appellant filed?
Let's see.
The second one.
Yes, you're right. Have the appellant files. Yep. No, got it. That's good.
This states promptly after the.
Yeah.
Would you want to be specific?
We have talked about that. We have not done that. And you'll see the word promptly in other places in this rule to account for that. But in less a specific way than you might think.
We were happy to take out that.
Moving to C, appointment of counsel. presenting and recognizing that appellate court types don't have either money or the ability to hold counsel to be appointed. It puts that burden on the Superior Court and then requires the state treasurer to pay for it. That is, from my mind, a restyling change alone. Or C, I'm sorry.
At the very end, it says on behalf of the state, we say on the state's behalf.
I have no, that makes sense.
I'm reading this, there are two separate funding sources for.
And I think that we talked about that. We talked about that because the appointment of the lawyers for the minors are very often from the offices of public defense services. And we need to make sure that we're not saying it has to be the state. If in fact this is, it makes more sense to have, an OPDS attorney out of Maricopa County or Pima County.
So that's, one comes out of the county budget, then the other one comes out of the state treasury budget.
And that is something that we noted as a possible impact, but we were thinking about conforming to practice.
Well, I mean, yeah.
No, and your point's a good one. It again, this change tracks the current rule as it's been in place for a decade. So I'm with you. I just.
Yeah,
that was
no,
the intent.
I mean, you should think, they really should come out of separate budgets.
Other comments on C? Yeah.
And I know, maybe it's implied, the certified transcript of the Superior Court proceeding.
Yeah.
I'm assuming that's free as well.
Correct.
Should we include that or did it say, I think there's very few, I think you said like there's only been one, but I would assume that no one would be charging for that preparation of the transcript.
That makes sense to me. Can we sort of flag that as a comment that we'll circle around back and talk?
I don't know, maybe
No,
they
no.
don't charge.
They should not.
Yeah,
Right. They should not. They should not. And I think we should make that express. Exactly how we do it. Give us a minute or two separately and we'll bring it back. Amy, did you?
No, I was agreeing.
No, that's a good point.
The period.
I think it's right, it's above there.
Yeah.
Above C, maybe put in a little.
Yeah, up on B, can we just drop a comment flag on that, Veronica?
We'll get to that. I'm sorry, Amy.
I was saying, can we just drop a comment flag on that, Veronica,
Yeah,
on B?
exactly.
Certified transcript, if you highlight certified transcript,
Pace.
above. Nope, not there.
There you go. Good.
No.
Good
Right
point.
in the line above it, it says certified transcript. Yeah, thank you. And then who pays?
Yeah, but I think you're absolutely right, Jessica. Other comments on C? So D, it deals with confidentiality. It's intended to reflect the confidential nature of these as well as the statutory directives. I have seen, and Bob, you pointed out something in there. There should be a period after 2152 in D1 right there. And then I'm not sure, and this almost has to be a typo, the court and appellate must maintain. And I confess, I noticed that immediately when I came in here this morning, not before, I apologize. I'm not quite sure what the right fix is, but I can tell you that's not right. And if we can flag that and think about it, not on the fly, but see whether that should be appellant, whether that should be appellate court, whether I just don't know. But if we can, Veronica, flag that with a comment.
I suppose you could say.
Could it just be the court
Courts and parties.
or parties or courts and parties?
I think so,
The original.
but give us a little bit of time separately to sort of ponder that if you would, because I want to make sure we get that one right.
Should say the records confidentiality rather.
So the suggestion is the records,
Yeah,
maintain the records confidentiality.
Not sure.
Well, I'm not sure how we weave the, in any hearing or other court proceeding back into that. So let's.
Yeah.
Yeah.
I'm the same.
And if you were to wrestle these things to the ground and say, hey, it looks like there's some things in the statute and the rules that don't seem quite consistent with reality. I'm with you, okay, but we're here to try to track the statute with respect to minor's name. For example, this is an authorization, not a directive, not a court order. Authorization for a physician to perform certain procedures. The minor's name candidly kind of has to be in there, but we're tracking both the statute and the current the rule. So the intent with D is to restyle, not to change the substance.
You're saying, Judge, that really the order has to have the doctor can't do anything with.
Doc's gonna want to know.
Like
the type
initials
people-
AB, they're gonna be like,
type,
oh, yeah, okay.
Okay, so E then, time for disposition, petition for review mandate. Again, quick hitter, trying to move, and there is a directive with respect to hours, right? 48 hours to move forward. Petition for review from a Court of Appeals decision. And again, we're in land that's never existed. There's never, to my knowledge, been a petition for review to the Arizona Supreme Court from the Court of Appeals decision here. Those need to move pretty quickly, but even then 14 days kind of seems like a while. But that's what we have suggested in there, recognizing that's the basis of the current rule. And then
C1.
yeah, John, you bet.
After holidays, you got an extra comma.
Yes, you're exactly right. You're exactly right. And John, I had noticed that in the clean version, although I'm working on the red line version. What was what's the subpart that you're referring to?
Oh, I was referring to E1.
E1, timing? All right. There you go. Good. Thank you. Good catch.
I have a general.
Yeah, you bet. You bet.
Did you review this with the constitutional change in mind? In other words, is any of this rule affected by the change in the Arizona Constitution?
That's the big, right at the beginning question that the group noted. In my mind, the statute still remains. And we're talking about somebody who is less than 18 years old. By definition, that's what these refer to. And so the rules are designed unless there's a determination that has changed to make sure that rules exist.
And you have to be careful here. The statute, the Arizona legislature made about 3 or 4 attempts to draft the statute, and it kept getting knocked down as being unconstitutional. Subsequent to the change in the Arizona.
No, long ago.
Right. So the statute as exists was the final culmination that survived constitutional inquiry. So I think you want to be very careful about tinkering with it. No, I agree, but this is before the change in the Arizona.
Absolutely. You're absolutely right.
So that could all be all that time.
If there is a determination sometime.
Right.
Absolutely.
Yeah, I'll add one thing, which is there's a pretty comprehensive constitutional challenge to about 20 different laws pending in Superior Court right now. I don't think this is within the scope of that challenge. So
that's interesting.
Not aware of it being included in the big case that's pending right now.
Oh, thank you. But that's a lingering question.
Yeah, gotcha.
We added the one change that I do want to mention in E is some significant, I'll call it granularity or clarity on mandate issuance. And I think that's helpful, but that's now 3A and 3B. I think one of the two headings needs to not be, or either both the headings need to be italicized or one
should not be
pulled.
Should not be italicized.
Okay. So if order is affirmed, should be good. Thank you. You're well ahead of me as usual.
Oh, gosh.
The effort there is to identify the different options depending on what happens for an order that's appealed through a petition for the challenge it. Statutory term.
3B3.
Yes.
Refers to the Supreme Court clerk.
Oh, yeah. I apologize, Aaron. Other questions or comments on E? F, the heading again is prompt actual notice. I think that reflects the intent of what is currently E. But it's restyled to make sure that's really what we're talking about and hopefully providing additional clarity.
I was gonna suggest this particular sentence is
Is long, John?
I would suggest after it says, notice of Superior Court order in the appellate petition, the period there, and a new sentence. The notice must be distributed. That way, at least you break up that sentence into two.
Yeah. And John, if you want, because we're talking about two different clerks, right? We could split that into pieces if you want. The Superior Court and Appellate Court clerks need to do certain things.
Well, the Superior Court have an order and the Appellate Court has a decision and then the mandate.
That's how this is.
That's a
Yeah,
basic
yeah.
question, but I'm just trying to.
No,
get
no,
terms.
that's exactly right.
Okay.
Thank you. And it's just.
What we could do if you want is to split, Superior Court must distribute notices of the Superior Court's order. And the Appellate Court must distribute to split, to divide the responsibility. And then the second sentence, John, the new sentence that you described talks about that needs to be done promptly in an effort to seek actual notice.
That I don't have a.
Do you
problem saying like in
Distribution must be, or distribution shall be.
Distributed.
I'm sorry,
Passive
John.
voice.
The notice must be distributed.
Yeah, but that's passive voice. And I'm wondering, and Ann was mentioning that in a manner calculated may not get something to the effect of the clerks must give prompt actual notice of the decision, something like that could.
Or designed to give. I mean,
Well, but as far as calculated to give or designed to give, like all of it, I think, is it really necessary when we could just say give prompt actual notice?
what happens if they attempted to but didn't?
I mean, they still tried.
Well, the current language allows for that. Courts must endeavor to give prompt. I mean, that's the concept.
It works, endeavor.
I made that up, maybe.
I think attempt might be better than endeavor.
Okay. Keep it, okay.
Yeah.
Oh, that's a good suggestion. Other suggestions on F? Let's turn then to G, no effect on validity. Again, that's a new heading. The effort is to restyle the undertaking here and to use terminology that's used elsewhere. Petition for appellate review, petition, related terminology there. The effort here is to definitely focus on substance. Let's go then, unless there are comments, I don't mean to rush things along, but I'm mindful that lunch may have arrived. So H, time computation, and this one's an important one. These, when we talk days, these are like calendar, these are days on a calendar. Without regard to intervening weekends or holidays. And again, a real effort to restyle it, no substantive change in new age, which was old G.
You know, you could say the time periods provided in Rule 1.2. Do not count intervening, in other words, take out the, that's it. Make it, do not count intervening holidays, weekends.
Do not count intervening. Okay, good, like that.
It's simple, make an imperative rather than passive voice.
Right.
Can we pick out this from for Rule 102?
We can't. We could just say under this rule, do not,
And after holidays, you could say with no additional days for mailing.
With no additional days being added for
Well,
mailing.
just take out the added.
No additional, okay.
Takes out
Okay.
the Right, Gardner would be-
Judge, are you saying here, you're not excluding weekends and holidays?
Because when we talk about days, they do not exclude, we do not count, we do not exclude intervening. I see it.
Days.
Right. So
Didn't-
that should be, I think, do not exclude, right? Not exclude as
The
opposed to
opposite.
count. Yeah.
Do not,
Exclude. Jessica, does that answer your question or was it a different point?
well, I just wanted to make sure it was consistent with what you just went over for time for disposition. Because the time for disposition for after the
Oh, yeah.
appeals.
Yeah.
And they have 14 days, and then it says any further appellate review must be heard and decided no later than 48 hours after the petition for review's filing, but
Excluding
excludes.
weekend, yeah. What if we put? Well, let me ask you though, does that first phrase there, except for time period specified for decision by an appellate court after filing a notice of appeal petition, does that do the work?
Without regard to intervening weekends.
Because that deals with E, time for disposition.
I mean, the time period.
The fact that we have 25 attorneys that are all not sure what that says, tell me that that's
Yeah,
not something we should use.
Yeah, we can take it around back, but what we could say is, except for time periods, except for disposition in 102E, something like that. Does that help you?
Yeah.
Because you're right. We want to make sure this is as clean as we can be, and we have in 102E excluded.
Yes,
submitter.
so that's why I was
Yep.
wondering if that was an exclusion to the exclusion.
Yeah, no, the real point, the hope in all this is to put kind of in neon that all these sort of 10-day, 7-day, 12-day things don't apply here. These are real days, 1, 2, 3, 4, 5. Other comments on H?
But whether so trying to decide whether to put do not exclude or include.
Include.
Yeah,
Includes clear.
yeah, include weekends and holidays.
Okay.
ahead and say.
Whatever the effort here, because it's so different than the direction that so many rule sets go.
Yeah.
And however we can get it as clear as humanly possible.
Yeah, I like include.
Includes better.
Yeah, that's good.
No, you are, and it is very different. A lot of the reason why we're not doing calendar days on a lot of these other areas is because there's conflicting statutes and conflicting rules. Now, this is all a creation of the Supreme Court rules.
Okay.
Should say weekends and holidays.
Oh, got it, yeah. No, this is really good. Other comments on H? And then what is now I, forms and instructions, which used to be H, is restyled from the rule. And there is, if you search for it, there's fairly robust help on the self-service center for the forms and the process for the.
I suggest that this court may issue on its website guidelines, forms, instructions, to implement the provision. Take out the.
And the other comment too. Yep.
Perhaps it should say this rule's provisions, essentially the provisions of this rule.
Yeah. How about just implement this rule?
Oh, yeah.
Oh, that's simpler.
Yeah, this rule.
This rule.
It's like 50% shorter. That's great. That's great.
How many lawyers does it take to screw around?
Right, no, that's good. Other thoughts? Yeah, I think Jose had a comment.
Yeah, just one comment, and I'm not familiar with this rule, but is there an inconsistency between saying this court may issue and dropping the words which must be posted? Should it say the court must post on its website? Would that be an accurate statement of the requirement, or is it a may and the post requirement in the that you just deleted wasn't really a requirement as such.
Good question. As I read the current version of the rule, it's a two-step. The court may do this, and if it does it, here's where they'll be found. Now, the court has done that. So they are found on that, but I think it's may issue, and then if they're issued, here's where you find it.
Okay. Thank you.
With the change, it's not clear that that's what it says anymore.
Got it.
I think it's still clear enough because it's saying we may issue, that they may go on the website. It's still, it's just directing how it's to be done. It's saying it may issue these guidelines, forms and instructions on its website.
The question, and I'm with you, Amy.
I don't think Jose is.
Yeah, so just one further thought though, again, at the end, it says to implement, which again sounds mandatory. If you're going to implement them, then it has to be posted on the website. Again, it's just a language thing. I don't know what the actual practice is or the intent of the rule.
Well, the other question I have is what if they have guidelines, forms and instructions that are not electronic and not in a PDF? Can they be promulgated somewhere else, or does it have to go on the website? I think you would want flexibility in that. But I'm not sure the current rule gives flexibility like that.
I hate to suggest adding words, but maybe you could get a little clarification that says this court may issue and post on its website to separate out the issuance and the website piece to account for that maybe. I don't know whether we want the must in there or not.
I wonder if may post. Yeah.
Yeah, you could just delete it and I think the may would cover it.
Jose, I think your hand is in there again. Not.
Jose, did you have another comment?
I'm sorry, I forgot to turn on my audio. Just wondering this, again, the significance of to implement. Does that suggest if you don't do this, that they're not implemented?
Yeah, at the roll out like.
Should you just drop the to implement if it's really not mandatory?
Yeah.
Does the statute require the court to?
It's a good question. Let me pull it up right here. I don't recall that, but yeah, from a quick skim, I don't think so.
So it really is a may.
Yeah.
So should you drop to implement?
Otherwise, it just says the court may issue and post on its website guidelines, forms and instructions. That just about what?
Yeah.
How about relevant to this rule or?
The application of this rule.
Well, then.
Assist and implement.
Related to, yeah.
John, I'm sorry.
To assist and implement.
To assist in implementing.
But yeah, it's true. Yeah.
Why do you need to assess? Just put implement.
Well, implement makes it sound like
Help
the
implement.
rule
Just
is implemented and like.
It shouldn't be dependent, the rule shouldn't be dependent on having forms.
Yeah.
They can help, but they're not required.
Agreed. But I think that was Jose's point. So it's just say to implement this rule, he's saying sounds like it's mandatory. I kind of agree, but I also don't think you can just entirely remove it or it just looks like a weird non sequitur. But I think saying guidelines and forms and instructions related to this rule. Related to.
To assist the petitioner?
To facilitate the implementation of this rule.
Okay, then we're adding more words again. That's okay if we need to do it to make it clear. If we think that.
Related.
I think related to is broad.
That's almost it.
That's right.
Right.
Word.
Perfect.
I think related to is. That's related to. I think it's.
So I'm wide open for a better word than implementing, but I wonder if for now we can at least use this as a placeholder because it really is it's really for the implementation and application of the rule. It's a self-help or self-service sort of concept. I like that word. Any other questions, thoughts on this? We have some homework, get it, and that's okay. That's okay, but this is really helpful. Thanks.
Lunch is there.
Oh, yeah. Oh, I would very much like to have a break.
I think, given the fact that we're just gonna have a brief update from work group 3, I think we're actually in pretty good shape. I was contemplating suggesting we work through lunch, but I think we actually have time to eat before we pick up work. So how about reconvening at 1 o'clock? 20 minutes of uninterrupted break time.
You'll say. And we're,
Wait till you're not.
with rule 91, I believe.
All right, rule 91.
Oh, in Seattle.
We were looking at trying to make this general rule that effectively talked about the general rules for just courts that just gave people an idea about what they can expect for the courts statewide, superior courts. I'm sorry, I should be more clear about this. And how they are administered, how they're organized and things like this. We tried to remove a lot of excessive wording. You can see this in particular in subsection A. You have to say the Supreme Court is always open. And we discussed the notion that we were deemed always open for filings provided by statute. We noted that it was difficult to determine how that's really being implemented in practice. We talked about purpose of filing any pleading or proper paper, and in particular, issuing and returning process. We simply do not have returns of process available for the most part after hours. There's some very limited exceptions, of course. We do provide, at least through Maricopa County, search warrant review to be available, initial appearance review to be available, child custody, or effectively child removal warrants for Department of Child Safety removal. Those are made available, for example, in Maricopa County by having a review for our all overnight initial appearances, but not every court does that. They'll have judges on call, like with Judge Metcalf in Pima County, and things of that sort. So we wanted to make it clear that we can't say we're always open when we're not. And so we did want to say that when the Supreme Court is open and what we are open for. So that's where that came in without putting in any of this possibly just not correct issuance and returning of process and making and directing interlocutory motions, orders, and rules. Yes.
That confused me when I first started the court, but I've always understood what that means is the court is always able to conduct business. Doesn't mean that the doors are open. I mean, it's confusing because of that, but doesn't that mean that a superior court, we have election cases, election night, they're going to decide a civil case middle of the night. So doesn't that really mean that it's more about the superior court is able to conduct business anytime rather than the court building is open?
Right. If you look to the next subsection, we do talk about the courthouses in particular, and we try to make that a different point. And we also talk about, and we deliberately worded A to, and as you keep reading in Rule 91, the entirety, we were thinking in particular about the ability of the presidings to deem that courthouses will be open extra time for elections challenges, to change the hours of courthouses depending on those issues. And so we did want to leave room open for that process. So when we look to, I guess, the entirety of the rule, and it may make a little bit more sense at that time, that is what we are looking for. If we meant that we may always be open, that still was not satisfied by the wording of the rules that existed. That when you say that, because it originally said the Superior Court is deemed always open for the filings provided by statute, purpose, or pleading or any other proper paper, issuance and return, a process and of making and directing interlocutory motions, orders, and rules. None of that makes clear, but we might be if we set that as a prospect. So we wanted to try to make that clear. Do you have a proposed different wording that you think would be better?
I want to think about it. I think I thought there was it's in the Constitution, isn't it, that the Supreme Court's always open?
We were trying to check countervening constitutional provisions, and I will make a note, if we can make a note.
Your statute, because when I first started working for the court, I thought, what does this mean? The courts aren't always open, but I was always instructed that it meant they could conduct business anytime, night or day.
Right, and we do think, we did discuss that, we do think we left it that, and nothing in here restricts that. But if you think we need a more affirmative statement of it, Veronica, could you make a note there to have me look for the constitutional provision?
There's a provision that justice is administered openly. Is that what you're thinking of, or is there a different?
Oh, there's a provision that talks about the courts, the Supreme Court's always open.
Okay, I will look for that, because we did look at openly, and
I think it's in Article 6. Could be mistaken.
And so when we look to when the courthouse is open, which I think is a distinction between the court being open and the courthouse being open, we did include both by local rule or administrative order setting the time when courthouses would open and close on each day. And we put both in there on purpose. We thought about just saying local rule, but then we thought, well, then you can't make the modifications by administrative order for things like election procedures.
Yeah, maybe it's the word that open is confused. It's always confused me. Maybe we said something like may always conduct business at any time or something like that would make more sense.
And that's something I can look at. Knowing now there may be a constitutional provision, I would want to square it. And so I'll definitely take a look there.
Yeah, it's Article 6, Section 17. The Superior Court shall be open at all times except for non-judicial days for the determination of non-jury civil cases and the transaction of business. And there's a few more sentences there, but just look at Section 17.
Yeah, I think we might have found that one because I don't think that we interpreted it as broadly as the Supreme Court rule used to read.
And there may be others. I just
Yeah.
quickly was trying to find.
No, I think that's it.
Because we talked about non-judicial days and things of that sort, having that sort of information in there, but
So it's the same about the Supreme Court, so you don't have to be on.
yeah. So knowing that we need to go back and look at that language and see what we can do to square that out. We honestly, I think we did talk about that already. It just sounds like it may not be satisfactory for everybody, so we can think about how to reframe it. We didn't want to completely take out when the Superior Court is open. But we also think that it can be confusing with what was already in there and not in conformance with practice or practicality. Yeah, Jessica?
Is courthouse like a term of art or should it be court facility to include like the clerk space?
We didn't want to.
Courthouse included, is courthouse included like filing counters?
We were worried about actually infringing on the clerk's authority as far as that was concerned. I knew that we define things for the clerks too. The way that it used to read, because it used to read time when court convenes. And in our opinion, that was different from the clerk's counters. And so when restyling it, we thought we would talk about as far as when the court convenes versus when the courthouse was open. That doesn't mean that we can't put more information in there to give guidance to
the filings. And that's where I guess maybe A and B, the filings would be coming to the clerk.
Well, and that's the other thing too. That's one reason why we didn't want to say that the court was always open for returning process, because we know the clerk isn't.
Yeah, we have the drop
boxes. You can file, but you can't get a issuance or returning of process. Do you just mean to receive? Because we could do that.
You can do your own formed copies. If you're returning like an affidavit of service or something, you can drop that in there, but you're not.
It said issuing though, and turning process and
Like
making.
process.
Yeah, go ahead.
I was just gonna say, the court doesn't push back, doesn't give you back something that the court is taking action on.
Yeah.
So if you want this back in, we were concerned that this might give people grounds to think that the clerk can provide more than they do provide after hours. And so if you want this back in, we can put it back in. We thought that actually would be kind of cumbersome and burdensome for the clerks, but we can put it back in.
I don't have a strong opinion anyway. I just didn't know if in B, and maybe I'll want to think if because the rule, I think you guys took, you said you wanted to be mindful. I think, is that why you took out clerks from the title too? Okay.
Yeah. So. Time when court convenes, we think is a little different from when the courthouse is open. And so somebody recommended that we, yeah, we could definitely just put all that back in there and say the Superior Court's deemed always open and then give some substructure for Romanet 1, filings is provided by statute. Romanet 2, purpose of filing any other pleading or proper paper. Romanet 3, and you don't need to type this, Veronica. I'm just thinking out loud.
I like
Romanet 4.
Filings as provided by statute. I don't really know what a proper paper is.
Yeah, that's why we were trying to make things clear. Okay.
Okay, say again, why don't you take the clerks out? There's never a time. If the courthouse is open, the clerks are open too. And I don't, sometimes we get some confusion over the clerk part of the court. So why did you take the clerks out?
I will be honest, I thought it was because we were concerned about infringing on authority. Doug, do you remember?
Because it goes on here to say that by local rule or order, how the court can set the time. That would say to me that court couldn't set the clerk's office time. That's not true.
Doug, do you remember why we did that? I thought that we were, I thought again, we were worried about infringing. And I think we were also just worried about wordiness. But if the clerks want that back in, we could put in, and that's in the title. Monica, if we want to go back up.
The title.
It's in the title. She's going. Okay. Anything else on title? Anything else on A? Do people think that it should add, I know Jessica says that she thinks it's fine as is, but do people think we should re-add in that substructure, Dave? The substructure for the different types of pleadings or filings?
No, that wasn't my concern. It's just what I think if you're a layperson, you're reading this, you now back to the court and go to the court at midnight and open the door on Sundays because we say the court is always open.
Well, that's why we were trying to avoid that misconception. What do you think we can do in order to change this without it conflicting with the constitutional provision?
I have to think about it.
You could just say justice never sleeps, but judges do.
Constitutional provisions about the court clerk, but they are subject to, I think in the Constitution, it says, the clerk shall have powers and perform such duties. It's section 23, the same article, as may be provided by law or by rule of the Supreme Court or Superior Court.
That's the authority of clerks?
Yeah, that's it. That's what's in the Constitution.
Right.
And then there's a statute, and then there's duties of clerks. But in the Constitution, it's section 23.
Right, so this rule would cover that. So if there's a Supreme Court rule, clerks would be bound by it. Correct?
Yes. The clerks have no duties in the Constitution articulated. It says everything's by rule or statute.
So does anybody think that there should be some changes to A? And if so, and again, I'm fine with what people want to kind of chew on it. Because we were trying to say, to make it consistent with the Superior Court is always open, and then move to the courthouse, the physical space, and make that different. But I don't have a problem with defining that out a little bit more. The Superior Court is always open for filings as provided by statute. Although those filings may be accepted by electronic filing or night Dropbox if the courthouse space is not open, something like that.
And you could say, you say something like the Superior Court may conduct business at any time. That's what I think you're talking there. It really isn't, the court isn't open. They can conduct business per the Constitution anytime. It's not, you know, if you want a warrant issued on a Sunday, they can issue a warrant. They're not required to only conduct business during operating hours of the courthouse. That's the distinction if you can word it properly.
Are people like that? Do we want to add the court? Do we want to take out open for filings as because it's redundant? Do people want me to reword that so that it has?
Maybe you could say, and can always receive filings.
You know, with e-filing now, we do have 24-hour.
Yeah, that's why I was saying.
Yeah.
We could say something is always open for filings as provided by statute, although that may be through e-filing and Nightbox. But Lacey had a thought, and can I hear that again?
Oh, yeah, I was, you could put a comma after time and say, and is always open to receive filings or something like that.
To receive. Do we need the comma?
You know what? All
we might
Superior Courts have Dropboxes. I'm assuming they do, but I just.
That's right. Like, wouldn't that fit
Can
better?
we, sorry, real quick, can we just take out that comma for and? Sorry, go ahead, Dave. I'm sorry, or Jessica.
Wouldn't that be better in B? Because we're talking about the courthouse, and if you said courthouse is open by the hours are set by administrative order, and you could say and may provide after hours ability to provide filings just for Dropbox, that kind of thing.
We could do that. I actually think it makes sense up in A because the courthouse may not be open. We could maybe add the additional information in B as far as night boxes or electronic filing, but I think it's the difference between when they may conduct business and when the physical facility is open. We could say the Superior Court is always able to receive filings as provided by statute on A. And then with B, the Superior Court in each county must by local rule or administrative order set the time when each courthouse will open and close on each day. And then maybe put after hours, electronic filing of documents or night drop boxes, or both may be provided. Well, maybe provided as passive voice, but.
A question, like a big picture.
Yeah. Let me get this wording real quick and then, yeah. So maybe after hours, parties may file documents through electronic filing or night drop boxes. As for, yeah, I like that.
I think you'd want to maybe modify, I don't know. There's some stuff you submit electronically and it's excluded from e-file and it gets rejected and it's deemed not filed.
Okay, so it's a may.
Okay, may file, but I just didn't want someone to say, oh, I'm gonna electronically file it, but it's one of the ones that's excluded.
Right,
So you could put the word submit, may submit file.
Oh, I like that.
Yeah.
Yeah. And what were you thinking?
But my question was, basically like, what is the purpose of 91A and 91B? Let's focus on 91A. So the Constitution already has provision stating that the Superior Court shall be open at all times. And so I would take it that the purpose of the rule is to do more than just restate what the Constitution says. It must be giving some sort of information or guidance to the people reading the rule. And so I guess that would be like my big picture question in terms of what to include or not include is how would a practitioner or a self-represented party use this rule? Like what information are they looking for when they look at 91A, separate from what the Constitution already provides?
Okay, so I think you may be right as far as A. If you're proposing to eliminate A, I don't necessarily have a problem with that. I do think we need B to specifically empower judges to make hours through local and administrative order.
Let's focus on A. And I'm not even saying that we need to eliminate A, but just more, I don't know, I feel like you could just say it's always open for business consistent with Article 6, Section 17 of the Constitution, right? If you wanted to cover all your bases. But I take it we have the rule because we're trying to give some sort of guidance or information to the intended audience. And so that's what I'm thinking is like, do you want to give more specific information about filing? Does it need to be more specific information about when the court may issue orders? You know, do you understand what I'm saying?
Well, so it would have been eliminating a provision, and I'm not saying that we're not able to eliminate a provision, but it was in the original rule. And so we were trying to make the rule more workable and less wordy and less misleading. What do people think about eliminating it? Do people think that there's a reason for it to be there? And
If it's in the Constitution, I think we have to make some reference to that to try to. Saying, you can't expect to hear back from the judge that night. You can file stuff, but there's no one there that's gonna sign your order at that point.
well, that's why it says receive filings. And I think I think that putting that information in there is good, that they may conduct business at any time and is always open to receive filings provided by statute. Is there something in there that Jose's got his hands up. Let me just finish this thought real quick and then I'll call on you, Jose. Is there something in there that we can link this back to the constitutional provision if that seems necessary? Jose?
My comment is as to be, so I can wait.
Okay. So do people want to eliminate A? Do people think that there's a benefit to leaving A in? And do people have proposed rework of A that they think may be helpful or they want to direct us to discuss?
I do think that A, with the additional language of always open to receive filings, does add more clarity when you look at it in comparison to the Constitution. So I don't know why we wouldn't give that clarity to people.
But could you combine that with B?
I mean, should we combine it with B though? I think that part of our mandate from the styling provisions is not to group things together if we can make them separate and clear. Unless people think that it makes more sense there. I do think distinguishing when the Superior Court can conduct business versus expecting the courthouse to always be open makes some sense. And I'm concerned about the style conventions of making paragraphs too long.
I like the fact we have an administrative order that can set the hours each day.
Say, what were your thoughts about B?
Just a minor change on the added sentence. After hours, parties may submit findings electronically or via night drop boxes.
I like it.
Thank you.
Amy?
Should we say if available after night drop boxes? Because I don't know that every Superior Court facility has one.
Well, okay, so Lisa had something too. She had her hand up. It's okay. Well, so if they're not available, then that's why may is in there, is my thought. Like if we put if available, we can, but then we've got also multiple clauses, after hours, comma, and then we have a comma if available. And I just think the sentence then becomes kind of strained. Do people know about how many Superior Courts do not offer night drop boxes?
I could double check. I think they all used to now. I'm pausing is people put sometimes nasty things in drop boxes.
Yeah.
I'm thinking during COVID, I can check with the clerks to see whether they do. They may have done something different because of.
Okay. If you could do that, and then Veronica, if you could put comment on night drop boxes for us to follow up with Dave with.
So Amy, I'm wondering why we're adding that sentence that we're talking about that we've just added. Because the way it reads to me is that a party can do it. But that would suggest if they can do it, that we're saying that we have to make it available. And I don't know why we're doing that.
Well, so the reason, and this was because this was a sentence that Lacey crafted, and I think it made sense. The reason why we talked about putting it there was to distinguish about when the courthouse was open and what can be done after hours. We can always take that sentence and move it back up. But the notion, and I think this was a reasonable notion, is that she was concerned that basically that people needed more information about how those things were to be submitted if the Superior Court is always open, but the courthouse is not always open, and the tension between the two. And so I thought putting it down there might show that the courthouse isn't always open, but you may still submit filings electronically or via night drop boxes. And that's one reason why I wanted to check and see what's provided in terms of night drop boxes.
But all I'm saying is,
I know.
doesn't that language create something that isn't, or isn't that a substantive change? Because now we're saying that a courthouse must have one or the other.
Right, I understand that's what you're saying, and that's where Dawn was making the proposal to just change it to if provided or if available, and that's why we're checking to see if they are provided or available. And we can make that a clause. We would just need to try to then figure out how to have the sentence not be so clunky. After hours, parties may submit filings electronically if available or via night drop boxes if available.
I think we should, I like the change to electronically, but I don't want people to see that and think they can just email something.
I was just gonna say that.
Electronic filing.
Yeah.
During COVID, like Maricopa County didn't allow, because we had e-file. I know some other courts, we wouldn't allow e-file. I mean, email, and some people think we do or thought we did, or, you know.
Does every county have electronic filing?
Yes.
Okay. But what's it officially called? The electronic filing, is that?
Different.
E-filing, okay.
But every section doesn't yet, right? I mean,
Not every case type.
Yeah, the probate and mental health do now. But
Well, that's true.
Does not, but no.
There's
Oh,
not
okay, what doesn't
electronic
now?
filing. It does not.
Okay.
right, so that would be misleading.
well, so let's say after out, so maybe we do say where available, parties may submit filings electronically or via night drop. How about that? That way we don't have the problem with the sentence being misleading.
Saying electronically or e-filing?
Okay, I'll get to that. Yeah, where available instead of after hours. And then submit filings via electronic filing or night drop boxes. And Jose, I see where you were coming from, but I do think that I already get so many people emailing my staff to try to find.
Yeah.
Yeah, no problem.
You need to put back in after hours.
Well, let me think about that for a minute, but Alex has something and then we'll go to Ann for after hours. Yeah.
This is just my own ignorance, but the drop boxes, do those get used weekends and holidays? And if so, should we drop the word night because it's kind of misleading?
Oh, yeah, we could do that. After hours, maybe after hours drop.
In Maricopa County, they can use them even during the day.
During the day. So we can just say drop
okay.
boxes.
They don't want, they're not interested in a
Okay, great.
form copy. I mean, I wouldn't, it would be my top priority.
So instead of doing the comment, I think the where available works. I don't know that we need to add an after hour. What do people think? Yeah, since we took out night, we can just say parties, where available, parties may submit filings. And then that way that also kind of shows the courthouse isn't open, but does say where available, there's submission options. What do people think? Good. Right, C. Assignment of cases. And here we talked about suitable provisions for organization and assigning cases and tasks to the different judges. And we wanted, again, we thought about putting in a requirement to be through administrative order. That's not always done in practice. And we didn't want to try to make it look like we were going to require that. So provisions, we thought gave enough cover to conform to existing practices. Does anybody have any thoughts on C? D, public access, and we wanted to keep that very lean because we know that our awesome crew for 122 is working on that. So we talked about court proceedings being publicly accessible. We did talk about the reason why we have if closed is required by law or ordered closed is allowed by law is we wanted to contrast taking specific note that juvenile cases are not mandatory closed. It's just they're ordered closed and allowed by law to be closed. So the same is true for court ordered treatment cases. And so as far as that's concerned, we wanted to have both of those clauses in, even though they look very similar, to cover both things. And then with public accessibility, we thought that was not only availability to the public view, it does also discuss, I think it also leaves room open for people to say, hey, do you have anything in here about accessible proceedings for ADA purposes, and I think that you can also discuss there that that's there. We have really separate provisions for ADA, and so I don't think that was a major focus on the work group. What do people think of D? And we know that 122 is taking 99% of the load on that, so we just wanted to keep it nice and breezy.
Does it matter that the old rule talked about what could be done in a judge's chambers?
We thought
Is that just not relevant anymore?
we were not sure that a lot was being done in chambers. We kind of wanted to even take note of, again, existing practice that for the most part, substantive things aren't really done in judges' chambers to a great extent anymore. I think one of the things we discussed were things like jury instructions.
What was interesting, I looked this up. Our rule was based, there's a federal rule, I think it's rule 77 for the federal rules, it still has that. And I never do anything in chambers with parties, almost ever, but I think it's an idea to push everything out into the courtroom and not do stuff in chambers. So I thought it was better to get rid of that
We thought
federal vestige.
both practice, both existing practice and best practice, for the most part, to do these things in open court where possible. And having the ability to control courtroom control, close the courtroom if needed or things like that, I think really obviates a lot of the desire to do these things in chambers, but also I think encourages judges to do things on record for the most part, which I think really judges should be doing. Maybe anything else on D? Oh, yeah.
The original, if I understand the strikeout, the original included conducted in open court and so far as convenient in a regular courtroom. And I'm concerned that publicly accessible may not have the same contemporaneous message as the original.
So we talked about this actually because Pima and Maricopa have different approaches for electronic hearings. Doug will tend to conduct his electronic hearings in his courtroom, just connected to Teams. Maricopa County, I will tend to conduct many of my electronic hearings from my chambers with me and my staff still in office. If anybody shows up, we immediately open the courtroom. They participate there. If anybody shows up and says they want to watch, we move everything in there and we also broadcast it into the courtroom. But I do know some of my colleagues will conduct a lot of virtual hearings from home. And we wanted to make sure that we were, again, looking at existing practice and not saying that they had to do everything in a regular courtroom if that's not a reasonable requirement.
Understood, and that's good. I'm worried about a judge who holds a proceeding and then says, we'll post the video later, and that's publicly accessible, as opposed to the contemporaneous, current language seems to say, right now, it's open. Conducted in open court and so far as convenient in a regular courtroom. But saying it's publicly accessible seems to open the door to, we'll do this now, but it's not open, but we'll post it online or we'll have a video available later on or something.
Okay.
So that's my concern about rewriting what's currently there to say publicly accessible.
We were trying to keep it broad to allow for that. I don't think it was our intention that there not be a public stream. Do you have proposed language?
I do not have proposed.
So our rule also is only trials had to be done.
Yeah.
In a courtroom. So this is broader, I think.
Okay.
Right. And I will be honest, for the most part, I actually do my trials from the courtroom, even if there is a virtual component. I think there's some limited circumstances where everybody says, people live out of state or whatever, and they want to do it online. But even then, of course, we've got the live stream option.
As long as we're not opening the door to something being publicly accessible after the fact.
Yeah.
And that's the distinct, and because that's not the way this is it's currently written, it seems.
And you achieve that by saying during the proceeding, end of that, so publicly accessible during the proceeding.
Yeah, I like.
Yes.
I don't have a problem with that.
I have language. Add.
Veronica, can we add during the proceeding at the end of the sentence? Yeah.
But indeed, why do you have, it says, says not closed is required by law or ordered, closed as allowed by law.
I think you were out of the room when I talked about this. We had a very particular reason for doing it. There are certain proceedings that are default closed, and then there are certain proceedings which are routinely ordered closed. And we wanted to leave room with separate clauses to indicate that both are true. And also because I think sometimes judges presume their hearings are mandatory closed, but actually do need to issue those orders. And so
What I'm getting at is, I think the court can order, like the Supreme Court during the pandemic, the court issued orders closing courts, but it wasn't as per law. It's under the Constitution, the administrative authority of the Supreme Court to run the courts. We limited access to courts by order, not, and that was not modified by law. So I'm worried about those, the last three words.
If it says law or rule, would that
Yeah,
address your
that's what I would say by law and rule.
But the Supreme Court acted pursuant to the Constitution, isn't that by law?
yeah, that's, a constitutional provision to me always feels like it's allowed by law.
I think law is defined in one or more places in the rules to include, it says, statute, constitution, rules, et cetera. Yeah.
By law is fine.
Constitution's vision gives the court the power to administer it. It didn't say anything about access. It does say courts are open, but during the emergency pandemic, there were limits by that the Chief Justice issued. I just didn't want that power to be limited by law.
Well, but law, as Alex is saying, is defined in multiple places already as including constitutional allowances. And that's why we say as allowed by law, not as directed by law, because we, again, didn't want to make it so narrow.
That's your point.
I have a question, Amy.
Yeah.
Is a court proceeding, would that include a Superior Court judge conducting a settlement conference where I go into the jury room with my clients and my opponent stays in the courtroom? That wouldn't be open really to anybody.
Now, I don't know if we considered settlement conferences in particular, other than in the criminal context. And so for a civil settlement conference, or, I would do them, I generally do them in family and probate as well. I don't know, do we consider that a proceeding? And if so, how can we carve that out? Because
Is court proceeding defined anywhere?
I don't know if it is. I could hear you talking. I just couldn't hear what you're saying.
I would say it's, I don't remember. But it's on the record. Yeah, that's, part of it's on the record at the beginning and the end.
Right, yeah.
So you commence a proceeding and then you go off the record to talk to the.
That's what I always did for those civil settlement conferences, but,
It's defined in Rule 122 that we heard just a little while ago.
That's right.
As a event concerning a court case conducted in a courtroom. And then courtrooms defined to include virtual.
okay.
Right, but I think Don's question is, what if they go into the jury
Room and then
which is a common
there.
practice?
Yeah.
That would not, I think, be classified as a courtroom.
Well, but is it publicly accessible? And I think that there can be an argument that there is a public access component, but how could we carve that out so that it's still permitted?
That's not publicly available.
It isn't, right? Because.
No, I mean, the beginning and the end part would be.
Yeah, beginning, yeah.
So portions of it would be, word closed is allowed by law. I think you can say that a judge is allowed to conduct a settlement conference in chambers. So maybe that portion of it would empower that anyway.
Yeah.
Order closed as allowed by law or court order? They're kind of the same thing.
Well, court order kind of begs the question. Then it becomes what was done because the judge, it was ordered closed because the judge ordered it. And so I'd be a little bit concerned about that, but judges are empowered to conduct settlement conferences. It's one of their duties. And so the confidentiality could be ordered closed as allowed by law there. Oh, what do people think? I think that there's an argument you could make that ordered closed as allowed by law would be empowered for that, because I will say this, and I don't know how yours are conducted, Don, but I sit down with everybody at the beginning of a civil settlement conference and I explain what we're there to do. And I say, now my plan is to caucus with people and you're going to be in the courtroom, but with the heard off and you're gonna be in the jury room and I'm gonna go back and forth between the two. And I talk about that whole process before it begins.
Yeah, that's what I'm accustomed to. And then if there's a resolution, well, even if there's not a resolution, we reconvene in the courtroom and either put it on the record or say, too bad.
Well, so wouldn't that be something that I'd be permitted to do by law?
I think it would be, but you need to order that closed. And that's sort of a flip, I'm guessing, of how it happens now, which would have an education component to avoid sad surprises. And I don't know if that's, we can do that.
Yeah.
Is that what we want to do?
I think it's probably allowed by law. You know, the settlement judges also have the parties acknowledge that there's going to be ex parte communications off the record. So maybe I answered my own question.
And I'll tell you, in Pima County, because we don't have enough clerks, all of our settlement conferences are off the record. We don't get a clerk for any settlement conferences. And we had to change the rules to allow for a stipulation of settlements, the silver rules. Sadly, we used to do it the same way, but it's we can't do that way anymore.
So Rule 16.1 and Arizona Rules of Civil Procedure, specifically subsection D, allows the court order that discussions between the court and a party or the party's counsel during settlement conference be treated confidentially and not revealed to others. So by rule.
All right. Can I potentially, that was another monkey wrench there, but I know in Pinal County in some of the courtrooms, because the jury box is so close, and I suspect this is probably true in other rural counties too, with smaller courtrooms, you would have to leave with the parties to do bench conferences. So how does this rule apply in that situation? Because you could be mid-trial and just leaving with the attorneys.
Well, I mean, it's not good practice to do bench conferences that aren't on the record.
Well, they're still on the record, but the court goes.
Comes in the back and it's.
Okay.
Yeah, so they're still on the record, but the public's not viewing them, viewing what's happening or the activity.
Okay.
So I don't know how that factors in or.
Yeah, I don't even know. I don't even know if that. So the way that this used to read is trials and hearings, orders and chambers. All court proceedings upon the merits must be conducted in open court and so far as convenient in a regular courtroom. All other acts or proceedings may be done or conducted by a judge in chambers without the attendance of a clerk or other court officials and at any place either within or without outside the county. So the old rule didn't empower that anyway. But I do want to be able to empower it, especially if they're still on the record.
Yeah.
To do it if you said instead of ordered closed is allowed by law, permitted closed is allowed by law, or closed as permitted by law.
Or closed as permitted by law instead of ordered closed?
Yeah, and you're not.
Yeah. Well, then we could just make it closed as required or allowed by law. Yeah, that can make it nice and lean. What do people think about that?
Yeah.
Yeah. Thoughts? Yeah. All right. E, decisions on matters within the 60 days. And again, we're trying to make this conform as best as we can with Article 6, Section 21. We wanted to just try to make it, easily understood language with the 60 days. This does concentrate on Superior Court judges specifically. And we did talk about the written reports. Does anybody have any, and a lot of this was cleanup language. Does anybody have any thoughts or input on E1 and 2?
You need a period at the end of 1.
Submission, yep. Good eye.
And there's also Oxford, comma, missing 2 for June, September, comma, and December.
Yeah, after September. Perfect. Thank you. Okay, anything else?
So,
Hold on, really. Wait, let's keep where we are. Don't scroll yet.
so the original talked about physical location. Is that someplace else? Was that deemed not needed or?
Oh, hearings outside the county?
Yes.
I think we moved that down. If I remember correctly, I'm sliding back and forth between.
Okay, that's if it's to come. No, I didn't see it.
We did eliminate that. I'm trying to remember why we eliminated that. So hearings outside the county, okay, yeah, I remember we did have a discussion about that and the notion was that people could not, that they couldn't make people, that basically Judge Metcalf couldn't come and handle a Maricopa County case but make everybody come down to Pima County for it. He would have to come up here. And we did remove it. And I honestly am trying to remember why. Do you remember, Doug?
I just thought, I don't think that it's ever the practice that would be outside the county unless people can think of a provision that you would have a Maricopa County case, but it wasn't being heard in Maricopa County.
Is there any concern about virtual hearings?
I think that I do know we discussed virtual hearings and what it meant to conduct the hearing outside the county because, if I'm conducting it in Maricopa County and I'm handling cases for litigants in Cochise County, has it now been conducted outside the county? And I do remember there was some discussion about that. So maybe.
Yeah, so for example, I have a case right now that I'm having in Santa Cruz County. And so I will call in to the system, but everyone else is in the courtroom, including the clerk of court, and it's on the record. Then if we have problems, something stops happening down there, but I'm physically in Pima County, but the proceedings still is in Santa Cruz County.
Right. So I think the question is, why did we eliminate that? I think there were thoughts that it may not be necessary because this isn't really being done with practice and that it may cause confusion with virtual proceedings. Do people think that should go back in? Any?
Well, absent some constitutional or statutory reason why.
Yeah. I think it might not have been a bad idea to have it in originally back when travel was so onerous on people. But yeah, and we also did not find thank you, Justice Montgomery. We also did not find a statutory provision or a constitutional provision that compelled us to include it. And so I think we did eliminate it. Okay. I see nobody's asking for that to come back in. So decisions on matters within 60 days. Does anybody have anything on 1 and 2?
I have something that I don't know if I will solve, but did want to let you know, because our office gets this question time and time again, is what does matter submitted mean? Yeah, or submission thereof. And I have to explain to them, it's generally like when the whole thing, when a judge takes a matter under advisement. So
when it's fully briefed,
response, reply type thing. And so people have asked me, upon what authority am I telling them that? And I tell them inside my head.
That's fair. And we spent a while talking about this. We were ultimately concerned that we would be stepping on statutory grounds if we attempted to describe it. But that doesn't mean that there may still not be a reason to describe it.
It was hard to describe for example, if one side files a motion and the other side doesn't respond, it should be submitted as of the deadline of the response and then that starts the 60 days running. If you have oral argument, it's when the judge takes it under. If the judge asks for additional briefing, it's after that's over. I mean, there's so many different variations.
And given that this is a creature of statute as well, not just Constitution, there's always.
And I just wanted to braise it.
I'm sure. I would want
that the public gets, because they'll see the under advisement reports that the clerk prepares and they'll say, my judge in my case didn't rule within 60 days. Why isn't he or she on there? And we get that call probably once a week.
I get people asking me this question in court. What does it mean? Why am I waiting 60 days from this when I submitted my motion to you at this point? And I completely understand that. That doesn't mean we shouldn't put in some definition language. And if people want us to do that, we can try to work some up. Jose?
Yeah, just a question. This is based upon my experience decades ago clerking for a federal court in California. If the judge decides that he or she wants further briefing, does that extend this? In other words, after they get the further briefing, is the matter then under submission? Or the way this is worded, it says must decide and enter a ruling.
Yeah. So, and I don't want this to be deceptive and make people think submission means one thing. And so if we want some definition, I will say the practice, and other people were saying yes as well, is if I order post-trial briefing on a particular issue, it's taken under advisement as of that day. And there's even a provision in the under advisement logs the clerk prepares for what we call a docs due or documents due date that then they use to pin their 60 days. So if I order briefing by December 1st, instead of taking something, instead of when I took it under advisement today, then they would have the 60-day ruling due probably February 1st or thereabouts, depending on the math, because that's how they have pegged it.
And again, it would be after a matter has been submitted
Right.
and then the judge decides they want further briefing. Does that order asking for further briefing constitute a ruling within the meaning of this rule?
The way that I think that I've been taught, and that doesn't mean it's correct, is that it's not fully submitted until all of the evidence has been presented to me and I have received all of the briefing that I have directed. So it's not fully submitted until that date, in this case, the December 1st date.
Yeah, but this would be a subsequent decision by the judge. So the judge has oral argument, takes the matter into submission, and then after studying it decides, I really want more briefing on X, and asks for further briefing.
So how can we make this clearer?
Well, I'm not sure you need to make it clearer. I'm not familiar with how that would be handled. And my question on the rule is whether that would be considered a ruling.
I think, Jose, what you're asking is, would the decision to request additional briefing constitute the ruling that would be made within the 60 days?
Yeah, that would be in compliance with this. And to be quite candid, there were judges in the Northern District of California who would do that so that they could extend the deadline.
Happened in Arizona too. This comes up all the time. Maybe a definition was easily called.
Yeah.
So submission means under advisement. This comes up all the time.
So from the so do you think maybe doing a 2 and say submission and defining submission there, or say from the matter's submission means this, or from the matter being taken under advisement?
Or what if it's is under submission for final decision or something like that? I'm not sure about that wording. It just popped into my head.
What if you said fully submitted? Would that cover?
See, every matter fully submitted to the court for decision, or later from the matter's full submission? What are your thoughts?
Yeah, paragraph 1.
Right, so I'm asking, where do you think which submission should be defining? Should it be every matter fully submitted to the court for decision, or, okay. What do people think of that? So I'm sorry, Veronica, not, if we just go up to 1 and just put fully before the word submitted.
Or how about this thing? What if you said in accordance with Article 6, Section 21, there was a question. Superior Court judge must decide and enter a ruling or decision no later than 60 days from the matter's full submission.
Yeah. Ooh, what do people think of that?
I like that.
Ruling or decision, and that makes sense, because then or decision kind of can go with like the scenario Jose was talking about. On every matter, no, or decision no later than 60 days from the matter's full submission. So we would take out everything between on and decision, the first decision. Yeah.
Are we still going to try and define submission or no? I'm not saying yes or no either way, but I didn't know.
Let me get this to where Justice Montgomery wants it, and then I'll come back.
Enter a ruling.
So sorry, real quick.
No later than 60 days from the matter's full submission.
And then put full before submission.
Complete.
I had a pretty clear recollection that we kind of decided as a work group to punt on defining this, because there's so many permutations. We can sure try again. I agree, it's delightful, but Jose's point, if you have oral argument and then gosh, I need more oral argument, or I need supplemental briefing, and after the supplemental briefing, I need more oral argument. It's just and there are ways to game it. I mean, no doubt. But I think there would still be ways to game it, even if we had a fairly comprehensive definition. That doesn't mean we shouldn't try some more.
Oh, and I don't disagree. But Jessica, I will say we did chase that. It was like chasing a paper and a bowl with a wooden spoon for a little while, but that doesn't mean it's not worth doing if it would help the clerks. Like,
well, I'm not in the.
Look at the next one. The clerks have to submit a report.
Yeah.
And the clerks ask all the time, what does this mean? When is it submitted? Litigants ask, we've had litigants file conduct complaints over submission. Yes. This is an area where it may be tough, but it'd be, to me, better to try to define it. It doesn't mean judges still can't game it, but they do that anyway.
Well, and so I'm interested in wording because we did try for quite a while in order to try to account for everything. But I'm open to what people, I do think adding full submission helps. I know it doesn't fix the problem. And Jessica went into this in a lot of detail. I
That's
think
just something like after all filings and arguments have been made and the judge takes the case under advisement. Something like that. I mean, I don't want to smith it here.
we can add that. I just think that then we're going to wind up with a, but what about this? And
here's a what about. We do lower court appeals. It's always very confusing about when the whole record is together. The briefs are filed to the lower court. Inevitably, my clerk has to go over there and start digging through and try to find things. It's very complicated. There's no right line oftentimes about where it's submitted.
Any definition is going to be very substantive, and it's really got to take into account all of these permutations that you all have raised.
And with administrative, when you file an administrative appeal, I think sometimes a judge will set a scheduling order or something. I can't remember now. It's been a while since I've had those. I don't remember if that's that going to work. It can be confusing as well.
We can take another run at it. I'm not optimistic we'll get 100% clarity, but we can get more.
90% of that is what we have now.
We'll work on 90. 90 will be our goal.
Maybe
instead of full is complete.
Stalemate on this, so why don't we take another run at finding submission? And with respect to this, we're way over time. Work group 1, we still need to hear from work group 2 and 4. We're now under 2 hours, so we're a little bit short on the last 2 groups, but and I was hoping we could push through and finish all of this with group 1.
sorry, guys.
But I think.
Can you make a flag on this for me?
What's that?
I would just ask Veronica to make a flag on this so we know where to come back. And so.
Sorry to stop the progress, but this seemed like a good point, because I
No,
want
thank
to,
you.
these
And I'm
other
gonna think
work
about
groups to
complete.
get, to make some progress as well with the task force. All right, so let's move to, and thank you, work group 1 for the excellent submissions and everyone for their comments.
That rule submitted.
Yeah.
Is it completely submitted?
It's fully done.
Ready to. It's playing on the screen, I think. Okay. Yep. So I will kick off, and I will be very brief, because last time we didn't even get to Judge Guard being able to speak, and I know we have Justice King. But we have been meeting, we've met twice as a work group since our last task force meeting. And I wanted to revisit this because this is where I think we got sort of stuck at our last meeting. And primarily, I think we were stuck around utilizing closed records and the order in which the definitions and terminology were set out. So what we went back to the drawing board on, based upon recommendations from the last task force meeting, is we really decided to break down the 2 types of records, get rid of the generally in the construction to administrative record and case record as the 2 types of records that would fall under Rule 123. So we came up with a definition for administrative record and a definition for case record. And so those are up on the screen. Wanted the administrative record to really include, be very broad, pertaining to management, supervision, or administration of the judicial department. It would include committees and boards, such as this one here. We have right now, or the office of any county clerk there, and we are considering taking that out. That was a yellowed sort of provision.
I think the word county is wrong. The county clerk would be the clerk of the board of supervisors. The clerk is the clerk of the superior court. They're a state office. They're not a county office.
Well, we put that there though to differentiate that the clerks of the Court of Appeals and the Supreme Court are not elected officials. So we probably, if we kept it there, it shouldn't be the clerk of the board.
Should be the clerk of the superior court.
Maybe it should be, or the office of any
Why, so you want to include the appellate clerks?
No, we did not. We wanted it specific that the appellate courts and the Supreme Court clerks' administrative records would fall under court administration, whereas in the counties, the elected clerk is not with court administration.
See, I don't see whether they're elected or appointed makes a difference.
And that's kind of why we had it yellowed to maybe take it out. We were gonna possibly take it out.
But I think we want to make sure that we are including the clerk's records.
We wanted to include the clerk's records,
Look at this.
but we didn't know if taking out or the office of any whatever clerk needed to be in there. If the definition on its own with a period, if they are assumed to being part of the judicial department.
Or you could say, or the clerk's office. See, sometimes there's been over time, there's been some debates from the clerks of whether they're part of the court or not.
Raise that. That's kind of what I was in my meeting saying, I don't necessarily feel this way, but the other clerks.
Yeah, I've been around long enough, we've had those wars. So if you just said, or the office of the clerk, would that include all the clerks?
You could do that.
Or of any clerk.
The main point is the records that the clerk of the court, whether the appellate court or the superior court, they're included.
Yes. Okay, so that's a great, thank you, Dave, for that suggestion, because it's kind of how it started to have the county clerk in there was the sort of position of some of the elected clerks. Then case records is broadly defined. We did talk about, including documents, papers, exhibits, transcripts, calendars, indexes. We are intending to revisit that just to look at the judicial code on records retention. Although we know that the code can be modified easier than the rules can be, but a broad definition there. So we are not going right now with closed records. It's not a total done deal. The majority of the work group thinks closed should really apply to court proceedings and not records, because generally someone doesn't tell someone you can't have this record because it's closed. It's been ordered sealed, or it's a confidential document, or it's restricted. And sort of keeping closed with proceedings and records not having closed as a modifier. It would be confidential, restricted, sealed. So that's that. And then
Wait a minute, don't we close all probate, all the financial records?
in probate, they are, in the probate rules, they call them restricted or confidential. They don't use closed. In the probate rules that are recent, we are cognizant that there could be a couple statutes out there that still use closed, but with the restyling of all of the rules as of late, like the juvenile rules and the probate rules, I think they've gone to restricted, confidential, sealed for the most part. There still could be some hanging out there closed. And then we thought if we did away with closed, we may want to put a definition in there that now says what closed is when we get later on to the other sections. So we have a note up here. Okay, then down to confidential. I think we covered confidential at the last meeting. You're struggling, and I shouldn't say struggling, it's been very good dialogue and discussion regarding confidential data and confidential information, and then confidential documents. So there used to be, my understanding, sensitive data and confidential information, and then you can have a confidential document. So we've all decided that once we really need to put a hold there, and as we move forward and get farther along in the rule about 123.6, that will have a better handle, because it's like you don't know what you're going to need to include until you know what all those things entail of themselves. So that's where I left, I think, off, and to turn it over to Judge Gard to move forward from last.
So last time, did we cover commercial purpose, I think? Do we need to go over that again?
I don't, I don't believe we did. Oh, then I can do commercial purpose.
I didn't have that one in my notes, but I'm happy to handle it.
Oh, no, I can do commercial purpose because you're not taking over till 14.
I have it down that I'm starting with information. But I can do commercial purpose if you like.
Oh, I can do commercial purpose. Okay, so that'll probably be of interest to some people that were talking before. So commercial purpose, we tried to see, and then sensitive data kind of goes along what we talked about, looking at it at a later date. If we need data, information, that sort of thing. So commercial purpose, trying to simplify the definition from what it was before. So we give 3 different samples that are set forth in subparts A, B, and C. So the sale, resale, or for the purpose of producing a document for sale. Obtaining names, addresses from court records for the purpose of solicitation or the sale of those names or individuals. We recognize that the court and the judicial code do allow for bulk data agreements, which do allow for people to come in and obtain bulk data, but it's not to be used for the purpose of solicitation. That's later on in the bulk data. And then if we can go down to C. And using a court record for any purpose in which a purchaser reasonably anticipates the receipt of money or financial gain from the direct or indirect use of those public records.
Is there a carve out for news reporting purposes?
So that was an interesting one. We talked about it for a while and I had raised it that sometimes there's been a debate with regard to media outlets or news organizations and whether or not they are commercial purpose or not. And we decided not to do a specific carve out for those and utilize these definitions.
Just for consistency, capital P should be small p, and that's what we've done it elsewhere. And also, I don't think you need the words I use as described in subparts A, B, and C law. I'll just say includes. When you're making a list, there should be a semicolon after A and B instead of a comma.
Okay. I can tell you, at least for Maricopa County, I know that for our records is when the media is requesting records, the records form asks if it's for a commercial purpose or not. It's generally not commercial purpose in our opinion, and they don't check that. But we don't also give them for free to the media as far as when it becomes costs and who you charge and who's exempt from paying fees for copying, which is a statutory provision.
Yeah, I just don't want there to, I don't think it would be good if there was kind of opportunity for mischief there. To have a difference in terms of the treatment of commercial purpose for court records versus the treatment of commercial purpose for public records under 39-121.3, I think is where the commercial purpose is.
Yeah, I think there's case law that says that, the problem with media is not a commercial purpose.
Right.
But the problem now becomes everybody's the media.
Exactly.
We used to have legitimate media you could give credentials to. Now everybody's just running with my own blog. I'm doing a newsletter. That's where it gets blurry. Well, what do we say? And maybe we haven't gotten there. What's the purpose of commercial purposes, Jessica, now with the new rewrite of this? What does it allow us to do or not do differently if it is a commercial purpose?
I don't think we've gotten far enough through the rule yet. The rule is such a long, I think it comes into play later for different access. Charging. Yeah, it's charging per document.
You could charge the fair market value of the data, right, under commercial purposes?
It's not for subscription. That's under the code section for subscription, both data, yeah.
I'll just wait for later. It's later. Let's just make sure we even need this because I have never found us determine something's commercial and then do something really different as I recall. We can charge anybody for the time it takes to go and do research and things, right?
No, you can't. I thought you cannot charge for research to locate a document. If you're doing research and preparing, you know, they just said, I need all the files for Jim Jones, and they don't give you any sort of descriptors. And my understanding is if it's for not a commercial purpose, there's certain things that you cannot charge for. And one of them is locating a document. So if you have to go to microfilm or you got to go find it, you're not able to charge for that. Whereas if it was for a commercial purpose, there's a definition that has you calculate, you can factor in staff time and my. Okay, so I don't have the rule in front of me. I've just got this book. I could pull it up. But so commercial purpose, we still think definitely needs to be defined because later on in the rule becomes a significant part.
It also tracks statute. That definition tracks statute.
Yeah.
With the exception of what's stricken.
Well, let's just look at that later when it comes up, because I find most state agencies cannot figure out what to do with the commercial purpose. And I know there's a fee in the clerk's fees for research. A lot of courts charge that fee. Because some of these records could be 25 miles away from the courthouse, storage sheds. Anyway, I think it's not for today. Get out there yet.
And then to note the deletion, we took out does not include the use of a court record by a political subdivision or using a court record in a judicial or administrative proceeding. To make it a little bit more streamlined. And then next up, we just did some restyling for court. Highlighted here, but it's highlighted in your book. And then for court administrator or clerk, we simplified that definition and took out language that we have. It means any elected, appointed, or employed individual who administers a court's operations or maintains its record. And we took out the part that I think was in the draft that talked about having some courts may have a court administrator and a clerk, or a clerk may have administrative functions, and there's some courts that don't have a clerk. So we thought that this combining them together, and then that also covers the Court of Appeals and Supreme Court clerks, as well as court administrators or court employees. And then court record would have been next, but we moved that. So it's at the very top with administrative record and case record. And we took out court record. And then we have custodian. It's now number 7. And I think the only change was access to records. And then now can I turn it over to you, Judge Guard? I want to move us along because I know these, but if you have questions, and then Justice King will have some more to add about sort of where we're going with our direction. This rule is really, I think, complicated, especially knowing that it applies to all courts. So we can't take the perspective of just the Superior Court or the Supreme Court, trying to take into account municipal courts and lower jurisdiction courts and documents that are in electronic form, documents on paper, exhibits. So it's a lot of work, but we're making progress. Judge Guard.
All right, so I'll pick up with number 8, which is information. So we've added a bit to this just on the concern that the prior definition was included any recognizable numerical data that constitutes a record or any part thereof. So we thought that wasn't broad enough to encompass things like maybe a photograph, a printed photograph that does not exist digitally, or a cassette recording, something like that. So we added language, including any audio recording, visual image, or other material, just to encompass that scenario. So we're not being too limiting. And feel free to interrupt me with questions, but I do want to save enough time for Justice King. The definition of judge. So what we've done so far, I think we just maybe added a comma there after arbitrator. But there is a note here to bring up to the whole task force whether other work groups are using the term judge. And I think the concern there was that, and I believe we had a discussion about this at the last task force meeting. I think the concern was maybe that term excludes magistrates. And I don't know if anyone has feelings on that, or if anyone calls the specifics of that conversation. But we did make a note to bring that up.
That suggests then maybe instead of saying judge means, judge includes?
Or we could just use the term, I believe, and Jessica, correct me if I'm wrong, but I believe we discussed maybe using judicial officer instead of judge. Was that the
We did have that discussion of using judicial officer, because I think there was, but then there was some, I think that we talked about using judicial officer because I know there were concerns about magistrates and then special masters.
Right.
I think that the courts, I'm looking at some, you guys, all the judges, special masters that may come in to manage discovery disputes. So judicial officer was being contemplated instead of judge.
But now that I look at it, we have judge means any judicial officer. So if those persons fit within the definition of judicial officer, then I think this is probably fine, especially if we change means to includes, as Justice Montgomery suggested.
And then we wanted to know, sorry, Judge, what work groups we're using? Are they using throughout the rule, so we are consistent with the rule set? Are they using judicial officer or are they using judge?
But we did
Or
have
are they
a
using-
definition in Rule 2, but I can't remember what we finally came up with.
Judicial
Well,
officers
that-
seem to use more, I think there's you probably look at the code of judicial conduct, because I think they have.
Okay.
And judicial officer, I think, includes referees and commissioners and so forth, so you could stop maybe there.
Dave, does it include hearing officers?
I think the judicial officer does include a hearing officer.
It does, the definition in Rule 81 does include hearing officer.
Okay, so
The definition, do we add the word God after?
Okay, all right. And I see Veronica put a note there. Thank you. So we'll come back to that one and discuss that. Law, we added, and we had a discussion, I think, when Amy was presenting about the constitutional provisions and how they should be included within law, and they were not in the prior definition. So we added language making clear it includes the United States and Arizona constitutions. We added the ACJA because there could be circumstances in these rules where that code is relevant. And in fact, one of our proposed additions is to an ACJA section. And then instead of where it said case law, the rule previously said case law, we broke that out and said ruling, decision, or opinion, which I think is more specific. And let's see. And I have a note here, revisit later and decide if this definition should be included. We can ask the whole task force for the opinion. And I'm wondering now if that isn't already in Rule 2, if it should be instead of here, based on the conversation we had this morning.
No, John, if it's in Rule 2.
Person?
No, law.
Person
Is
in-
law
in-
defined?
No, it's not in Rule 2.
I wonder if that's something that we would want to have at the very beginning for all the rules. Yeah.
That seems to make sense because I think it'll be applicable kind of across the board. So maybe Veronica put a note there to consider moving that into.
Lacey, would it make sense to spell out what ACJA means unless it's abbreviated nearby?
Yeah. Good catch.
For folks, here, just quick question. If we do define law in Rule 2, my thoughts would be to still keep it as the same definition in Rule 123, just because I feel like so many people that aren't looking at the entire Supreme Court rule set, that are just records folks, go to Rule 123. Now, maybe that's poor. I'm looking at John Rogers. He probably wants to kill me. But, we want people to obviously be well versed in all the rules, but a lot of times it's like records Rule 123 and they're not going. Does that make sense? Or is that just too bad, so sad? Go read the definitions. I don't know.
And that would apply too to the next one, person, because our note there is to see Rule 2, because Rule 2 does have a definition that is, I think, essentially identical to this one.
If we're gonna have definitions at the beginning, we shouldn't repeat them, or we shouldn't have the definitions at the beginning. I mean,
I know.
those things are designed that way, statutes and stuff. It's, you have definitions at the beginning, as used in this title, it'll say.
Yeah.
And you gotta know to look there. I mean,
I know,
just the way that
I
the
know.
laws,
I know.
long before any of us were born.
Well, I wonder if we could consider putting something at the very beginning of the definitional section for this rule, referring the reader
that's a good
back to the
idea.
Rule 2.
These definitions are
Yeah,
in addition
in
to
addition to-
definitions.
Yeah.
Like telling them like, wink, wink, nod, nod, go
Yeah.
look there.
Yeah.
Got a comment?
Yes, do we want to consider adding published to modify decision or opinion?
Well,
Am I being too nitpicky?
not every, you can now cite and publish decisions within certain rules and parameters.
They're
But you
laws.
could cite them, but do they create precedential law if they're unpublished?
They could be law of the case too in a particular case.
Yeah, that's true.
But then that's court
It could be
order.
law, but
Well, that's true. That is an order. Yeah.
That's fair.
Well, and I think here, part of it was if for records purposes, if a lower court orders something sealed, clerks aren't giving it unless, you know what I mean? Like, it might be up on appeal and maybe even the issue has to do with that document, but we're still not. We're just saying Judge Smith, we're looking at the order and saying Judge Smith has ordered this sealed and you can't have
Document written.
So maybe should we put a note then to back at that one? That let's see, the court, I guess would be the ruling decision or opinion section of it, and then whether we should limit this published. All right, number 12, oh, sorry. Okay, person we talked to, and so I guess that's the same question. So we have a note here, whether it's necessary, because we have it in Rule 2. Number 12 is new. So this is where we added in personal identifying and sensitive information based on our conversation at the last task force meeting. So we also do have a note, this is a work in progress. This is one of the rules that we will revisit after we get through 123.6. But for now, the working definition, and if anyone has thoughts, feel free to give them, is social security numbers, driver's license numbers, bank account numbers, credit card numbers, their financial account numbers, or alphanumeric combinations.
Aren't your biographical things, your date of birth, address, all of those, aren't those all covered too?
Did we discuss that, or maybe
in the statutes that talk about personal identifying information, that the dates of birth I know are not included. And people have our height or weight or eye color, those descriptors are not included.
Yeah, I've always found this strange, but there's DOBs all over Superior Court stuff, especially in criminal cases, right?
So that's always concerned me though,
Yeah.
because if I were a criminal looking to do ill, I could just literally data mine all of that information and.
That's how we identify it.
That's some people love the date of birth if you have a common name, like they love it on the document so they can prove that is not them
Yeah.
as well too.
Yeah.
I think
Yeah.
date of birth, I can pull up the statute or you may in the public records statutes or the statute that talks about personal identifying information, date of birth is not covered.
Yeah, it's
Well, things like-
surprising.
Things like DNA, why is that not sensitive information?
Didn't even think about.
I mean, I don't really know what courts collect in term of DNA that would be identifiable. Like they don't, there's no sample.
Like a
There's
pro, like
also-
a.
So we have other provisions that, so that's kind of backing up a little bit. We have in Rule 123, we have this presumption that, so we did away with the closed versus open concepts because of the confusion. But earlier in our last work group meeting or task force meeting, we talked about, so Rule 123 has this general presumption that all records shall be accessible to the public, except those that are, restricted by applicable law or due to privacy, confidentiality, or best interests of the state. So I think something like DNA would, arguably fall within privacy or confidentiality. But above and beyond that, what we're also doing, and I'm sorry, Lacey, I don't mean to interject, but we've decided this new structure of, okay, presumption of publicly accessible, except there are exceptions. And those that I just mentioned are going to be exceptions. And then we have down below in Rule 123.6, the current rule has case-specific information. So like juvenile records, Rule 123 already says that. Juvenile records, here are the type of records that are accessible and those that are inaccessible to the public. And then there's, I think I wrote this down, adult criminal, mental health, that's in the current Rule 123. But what we're going to do, we're gathering this information. What is beyond that? So there's family court. Let's give the type of records that come up often in family court. Well, which ones are going to be accessible to the public and which are going to be inaccessible? And so we're gathering that information for family and probate, civil. And so we're working with the presiding judges. I've reached out to the presiding judges of Maricopa, Pima, and Pinal just to say, hey, you all are subject matter experts. Your family court presiding judge, they are probably going to know what are the types of records that come up that have that confidentiality restriction in it. So we're still gathering that information, but remember, we're looking at personal identifying and sensitive information. That is not going to be, that'll be inaccessible to the public, but there's also other provisions too, including confidentiality and privacy, best interests of the state, other applicable statutory provisions that would be in play. So that this is not just this. We're not just looking at this.
There
You've
are
added that.
concepts here. There's what's published on the net versus what's available at the courthouse. Like in family court records, we don't publish them. But I think unless a family court record is sealed, I think family court records, everything is open.
Everything with the exception of like most of the case types and way back when they didn't have that, but like they now have different document categories where in those cases like family court, the sensitive data sheet.
Oh, yeah, the sensitive
data sheet, that's restricted.
The affidavit of financial information.
Yes, affidavit of financial information is automatically restricted.
Restricted document.
That's if they put it in their sensitive data sheet, right?
No, that's separate because you're required to attach pay stubs and tax returns to the affidavit of financial
Okay, so the
information.
clerk doesn't share that if they come into the courthouse.
That's restricted. Yeah.
What about like psychological reports and medical?
Those I might order to be restricted and I often will, but they're not automatic.
Yes, in criminal though, in Title 13, competency, those are restricted.
Yes.
The medical reports,
Yeah.
restricted document type.
Right, and that one is, and there's very specific rules in Rule 11 of criminal procedure for those reports and the limited purposes for which they can be disclosed.
But Dave, what I did want to share with you, and we talked about it in our group, is so if someone should attach a boatload of checks or a boatload of things that have personal identifying information as Exhibit 27 to their motion for summary judgment, it's in there and it's publicly accessible. Or in family, we've had people that, you know, you kind of want to cringe a little bit that they decide they want to file a motion that's a publicly accessible motion, and they attach all different psychiatric reports about their kids, and they didn't make a motion to seal. Now, whether a judge on his or her, you know, will say, hey, hold off.
And we will tend to make those restricted or confidential documents as opposed to sealing. Because of course, keep in mind, if something's sealed, can't even look at it. And neither can the, you know, if the motion's been filed and happens to have the attachments, you know, the other party can't really, you know, pull them up. So we will tend to make those more of the confidential and restricted document. I did want to, what I was trying to interject though on, and I do want to make sure everybody's aware of this, is because of the Violence Against Women Act, orders of protection, that entire process is those are not open to the public.
Until served.
Until served. And then even the proceedings are not, have different rules as far as the confidentiality and disclosure, which is actually one reason why we don't take an order of protection, even if it's between parties who are, say, divorcing, and combine it with the divorce case. They have to remain separate because of the different rules for how we manage the court records.
Does it have to be combined with the divorce case?
No, you can hear them in concert with each
No,
other.
I thought there was.
You can hear.
Had to be.
No, you can hear them at the same time.
Okay.
You can even order they be transferred. Let's say somebody filed in.
Oh, that's what it is, transfer, yeah.
Yeah, you can even, let's say somebody filed in Florence City
Yeah.
Court.
Yeah.
You would probably then transfer it to Pinal County and have the same judge hear both. Right. They have to be separate cases. Got it.
And also you might want to take a look at 134434. That involves victim identifying and locating information.
Yes.
We did talk about that, yeah.
There's requirements and exceptions.
And I think we looked at that too, Justice Montgomery, and we were going to do a little bit of further looking on that, on where the duty lies when it's being filed with the court. Like, not to say we want that out there, and I can tell you clerks have sometimes bought things and said, hey, talk to the judge and put a hold on it. But where does that burden when it's being presented and it's to the clerk's office?
Yeah, and I think so, I mean, within that statute, some of the records that are accepted from it are records that are transmitted from law enforcement and prosecution to the court. Then there's another provision in there about disclosing any of that information that could fall within a public records request, so.
All right, so that was the work in progress. Presiding judge, I think we just made some restyling changes. Let's see, nothing really too.
You know, you might, depending on what the rest of the rule says, you might also have to define presiding municipal court judge and the presiding JP.
So
you say here, it means the presiding judge of the county. But I think when we get into the substance of the records, I think if a local court, I think the presiding judge can deny something being released, they mean the presiding judge of the municipal court.
So, okay, so maybe I'm not understanding, because we do have a presiding judge for justice and municipal courts means the presiding judge of the Superior Court. Is there a different?
Yes.
There's another one?
Yeah, there are separate presiding judges of, say, Scottsdale.
So depending
Oh,
upon
I see what you mean.
says,
I see it.
who denies access to a record, I think there's gonna be, in some cases, the presiding municipal court judge and the presiding justice of peace.
Okay, so we need
I
to.
think though that the presiding judge of the Superior Court is the presiding judge of the Justice Court. Haven't we had a big?
No, there is a presiding judge of the JP courts, and then the JP himself is the presiding judge of their individual court. But here you're defining it correctly.
Okay.
We mean presiding judge, we mean the presiding judge of the county right now. Later on, you may have to come back and put definitions of the other people, and so it's clear what we're talking about. Because the Maricopa presiding judge does not sit there and decide whether or not a justice court record is going to be released.
I don't know if that's still Tama County. I mean, we oversee the Justice Court a lot.
You're different.
Yes,
because
we're different.
Your presiding justice is the presiding judge.
Right.
Other than that, you got 23 municipal courts in Maricopa County alone. And the judge does not, the presiding judge doesn't decide about record release.
Right.
So maybe we should put a note there too, just to take another look at that. Definition.
Whether this applies, who's making the decision about release of records for municipal and justice fees. I don't know if we've moved far enough. I don't think we have. I think part of this too was later on in the rule, the current rule says for anyone to post a record of mine, they need the permission of the presiding judge of their court. And so that may be like, so Maricopa County goes to the presiding judge to be able to do that. And that may be why it's defined.
Yeah. That could be. All right. Private organization serving a public purpose. So we added educational, let's see. Or did we? Yes, we added the word educational, and then we added the citation to ACJA 1-606, which is the provision that allows courts to give access to public agencies or those agencies that serve a public purpose under record access agreements. So just to refer the reader to the authority that exists on that topic. The public. So that's another one we're going to return to. We do have notes there about how it doesn't quite make sense with some of the other definitions. So this is something we'll take another look at.
Although I will tell you, we actually have had JPs taking public record requests for other JP's emails in Beaver County.
Really?
Yeah, so not that I encourage that, but you have to understand around the state, there's sometimes hostility amongst judges. They want to file a request to get the other JP's emails.
Interesting. Okay. All right.
I don't know how we deal with that, but it's maybe not as nonsensical as you think.
Okay. Okay. Well, okay. All right. Well, all right. So we'll come back to that one as well. And then the last one is record. We still have a definition. Oh, sorry about that. We still have a definition, just a general definition of record here. And Jessica explained how we broke out administrative and case records.
What does other materials there mean though? Especially when it says in physical items. Let's say you have a gun. I mean, do you make a records request for the gun when you say other materials and physical items or drugs?
Yeah, yeah.
Could you just look at that? Because I think we're starting to get broader than what everybody thinks of as a record.
Could we say excluding evidence? Excluding
physical evidence?
Yeah, excluding physical evidence would probably exclude a lot.
The media or public can come in and we have a whole exhibits department and we pull out the physical exhibits. Now, we don't say, here, you can take the gun with you for like a few weeks and, then bring it back to us.
These are
But they
record requests. This is not a request to view the evidence. They come in, we do that. But now we're talking about, can they make a request?
It's public access, isn't it, to public access? The Rule 123 is broad.
Yeah, and they have the right to inspect it, right? Not necessarily.
Maybe they just need to clarify that. They
Yeah.
can inspect it, but they can't get a copy of it or a sample.
Limit that to.
Those things, yeah, they can't.
Yeah, oh, yeah, because otherwise they'll.
Otherwise they'll,
Start missing the guns and stuff, yeah.
Handle it.
Yeah, view, okay. All right.
Little note there, then, that maybe clarification is needed on inspection of physical evidence.
For Justice Montgomery suggesting using the word view.
I'm sorry, I didn't hear that.
Yeah. Because he pointed out that someone could, manipulate a gun or something like that if we say inspect. Yeah. Yeah.
Oh, absolutely.
Yeah. Yeah, so.
Okay.
Oh, by the way, we do collect DNA. Our probation departments take a DNA sample of every probationer. We also have now DNA urine sampling. So again, I don't know how that plays out. I don't know what records we take. We take the sample and turn it into the labs. I'm not sure what records of any of the probation departments keep. But we do take samples. We do have DNA urine samples now, so you don't have to observe someone too.
Do we store the sample? Yeah, I mean, is it stored as a record of a profile or? I mean, I could see that we.
I don't think so. I think it goes off to the company that does it. They can prove it's the person. We just get back it's positive or negative, I think. But if we need to, I could check further on what we keep it as.
Let me ask, the clause in connection with the transaction of any official court business or activities, that suggests to me that the courts are getting these things and just holding them otherwise. And that, I'd be really surprised if that was the case. So I wondered if we needed that phrase.
Is that in there? Because I know our clerk brought up a circumstance where someone had given the court some like a identification card or something that had nothing to do with the case. Is that why that's?
Yes, I think we talked about, so we have collective, received, or maintained. A lot of times, at least from the clerk's perspective, is we can receive on the stuff that's not related to any
Court business?
proceeding. Yeah. And generally these people may not be your average litigants, but you know, and so it's kind of like, do we file this into case file? If there's a case file, what do we do with it? Do we, you know, this, we don't even know who this person is. Like someone will say, well, if it gets mailed to us and it's in our mail room,
it's good.
You know what I mean? Like I handle all the time, like your requests for like 1099 forms, and I don't know where these people are even from or.
No, that's helpful.
Okay,
Thank you.
so I think that's why it's in there. I can't remember, but it was kind of like, we don't necessarily. We collect and maintain, but not necessarily everything that's received. Although it's still, if it's in our possession and someone wants to inspect this, it's a public record. It just may depend on how long we have to retain it.
That's helpful. Thank you.
Okay, so this will be really brief. So I was going to address the revisions to Rule 123.2, which talks about records management, and a large chunk of that is redactions. It was just brought to my attention, there's actually a statutory provision. Marita and I were discussing this, ARS 18-522, that I think is going to require some revisions to this. Not substantial, but I just don't, in the interest of everybody's time, I don't think it makes sense to walk through Rule 123.2 when we will be making probably some revisions to that to conform with statute. And then Rule 123.3 is very short, but I think we can just cover that up and talk about 3.2 in the next task force meeting. So I think we'll go ahead and wrap up a work group 2 for now.
I don't know what statutes you're referring to, maybe things that apply, but you know, historically, our court's taken the position that the court's rules govern our record keeping, not statutes.
Yeah.
Just make sure we don't suck ourselves into statutory scheme.
No, it's just adopting commercially reasonable procedures to protect personally identifying information. So.
Thank you.
All right, well, thank you, work group 2. I believe Aaron, when he returns, but he can. If you want, Aaron, want to give your brief update for work group 3? Oh, hey.
We've been meeting and working. We don't have any work product to show here. Work group 3 is working on the attorney admissions and related discipline rules. And in August, it just passed, the court abrogated Rule 35 and replaced it with a version that addresses the next gen bar exam that's coming. And that took place after AOC staff restyled these rules that relate to attorney admissions and discipline. So there were a couple of changes from August of 24 and August of 25, where those court adopted provisions didn't make it into the version that we're restyling here. So that has to take place now. So that's underway, so that once we get the court approved versions to the restyled version, we'll keep working on those from there. So we met twice in October to discuss the restyling and those updated versions. And we have meetings again October 29 and November 12. So we think by then we'll have, everything will be combined. All the drafts will reflect the latest of everything. So we can pick up from there and have something to bring to our next task force.
Thank you, Aaron. All right, it's time for work group 4. Justice Montgomery.
So we still have Rule 41 and 41.1 under advisement. That matter has not been fully submitted. So we'll bring that back at a later point in time. What I'm going to do is go over as quickly as I can, Rule 42.1, which is the Ethics Advisory Committee. Now, this rule has been amended twice within the last 5 years, most recently going into effect January 2023. So we really just focused on restyling this particular rule. And then following that, so far we can get, Mr. Don Wilson will review Rule 44, because again, as Justice Slope has mentioned, we're going to reserve Rule 43 and its proposed subparts to a future meeting. And Maria Lisea will take a look at Rule 45, and then Judge Lisa Vandenberg, Rule 46 and 46.1. And then Mr. Ken Volkmer, who is waiting with bated breath and on edge to get a chance to present before we wrap up. So Rule 42.1. So what we've done here, again, this is all restyling. The only particular areas that we took a look at adjusting was how the Chief Justice appoints at least 9 members of the State Bar to the Ethics Advisory Committee. And then we specified that in making this selection, the chief is to consider, is considering a variety of practice areas. And it used to read settings, practice settings, but we figured what's better for that is to say practice sizes. We know from a recent survey done that there are different concerns for members based on whether they're a small firm, solo, or large, and that's usually driven by the practice size itself. So we've altered that. Also, after the reference to Chief Justice in the middle there, Veronica, so I think it's about line 8, it says a members, and it should be a member. I caught that before John did. And then again, the rest is restyling here. Any questions or concerns about 42.1A, membership of the Ethics Advisory Committee? Okay, hearing none, we'll move on to 42.1B, the scope and duties. We changed this from powers to powers and duties, since that's kind of redundant. So we reflected it to what's actually being considered here to scope and duties. So the EAC may issue opinions as provided involving lawyer ethics, legal paraprofessional ethics, and then ABS ethics. Then with respect to the authority to issue an opinion, we reworded this to tighten it up, and then it can be on the request of a State Bar member. And they also address questions regarding the conduct of an ABS or a compliance lawyer's own proposed conduct within the context of that ABS structure. Okay. Questions or comments? Moving on to 32.1Z.
Justice Montgomery.
Yes. Yes, John.
I just, and these are purely stylistic, but it may be help clarity to rule if you include subheadings for 1, 2, and 3. So for 1, just a subheading saying opinions, 2, rule petitions, and 3, legal education.
I like that.
And then in the listing under 1, it really is a list. And I got that formatted accordingly. So I have A, to make sure it's all part of the same component. I would strike the words the EAC, which also in the addresses. So it says on the request of state or member, including questions.
I like that too.
And then include semicolons after each subpart instead of periods. And we get down to D, these semicolons. And then also in C, because Rule 2 defines Supreme Court as court. Supreme.
Okay. The question is referred to by the court or the State Bar. Okay. Without objection? So amended? You capture all those, Veronica? Okay, that would take us down to, if we look at 2, then rule petitions. The EAC may file rule petitions with the court recommending amendments. There was a question that we took up whether that was too restrictive. Could the EAC address any other type of rule petition? And we left this basically with where it was before the original rule, unless someone's got an argument on why we ought to expand the ability for the EAC to address other rules petitions. We'll leave it at that. Yes.
Was the thought maybe the EAC
for example, may want to amend Rule 43 having to do with trust accounts because that intersects with professional responsibility, but technically it's not part of the Arizona Rules of Professional Conduct. Was that kind of what your working group was thinking of?
Well, just really with the EAC, it pretty much focused just on the rules of professional conduct and ethics questions. Now, I mean, the trust account rule that can raise ethics issues.
So I'm the vice chair of the EAC right now, and I would say this has never come up in any of our discussions, whether we felt like we're too limited, by looking only at Rule 42. But I could see how potentially, I don't know, except potentially there could be some other, adjacent rules like Rule 43 that could impact legal ethics or professional responsibility. But I suppose we could always recommend to somebody else, like a state bar committee, that they make the rule petition.
We're in the middle of this. You do me a favor. When's the next EAC meeting?
December.
Okay, well, that's within our time frame. If you want to take this back to the EAC and just ask if there's anything that the committee feels that they would need to be explicitly given authority for that would help with carrying out the duties and responsibilities.
Will do.
Okay,
Yeah.
okay, thank you.
This is the language in the original. This is the
Yeah.
original as it exists, so it'd be a substantive change to go beyond.
It would be, yeah,
Yeah.
since we're on it.
In that connection too, as I recall, when this rule was last amended, it was the petitioner was the Ethics Advisory Committee. So it may be recommending amendments to this rule or to the Arizona Rules of Professional Conduct.
How about that? Okay. Any concerns or questions about that? Let it be said, so let it be written. All right, that'll take us then down to particular, it used to read prescribed areas, now it simply reads prohibitions. That limits what the EAC can be asked to do.
I think the subheading that was added,
Oh, yeah, legal education
go
programs.
up a little bit, Veronica.
Because I think we put judicial, we should have put legal.
It's not-
Sorry, legal education.
Legal.
Thank you. And then all we've done in this area is when you get to C1, just figure out state bar affiliate member, given the definition of member for our rules and ABS instead of alternative business structure. That's good. Okay. And then the remainder of this is exactly as it was before. Would you please scroll down to administration? We reworded this to tighten it up. No substantive changes.
Montgomery.
I would suggest using subheadings here as well, just for clarity, with subpart 1 being chair, subpart 2 meetings and communications, subpart 3 staff.
Okay. Without objection? So amended. Aaron?
Question on that, sub 2 about where they meet and that sort of thing. I don't remember other boards or committees having that level of specificity in the court rule. A lot of that's covered by the judicial code 1202 public meetings.
Yeah, the previous rule stated that the committee may receive mail at the Supreme Court's address and will meet at Arizona State Courts building in Phoenix. So it even had greater specificity.
Yeah, it's odd to see it treated, EAC treated a little differently than any others. If it's just a restyling matter.
Yeah, that's. Do you want to propose a rule change?
I would just pull it out. Because it's in one.
Well, I don't know, I think where they get their mail and how you communicate with them may apply to the fact that members may want to know where they go in order to request an advisory opinion.
And which is all on the website, like some other boards. Doesn't hurt anything to be in here. It just caught my attention that it's sort of unique to EAC, I think.
I think that's what draws some people to be a member of it.
I think when this rule was last changed, there was some sensitivity about this is going to be the Supreme Court's Ethics Committee, State Bar. That's why it got in here to be in this building, I believe, but I'm not sure it makes any sense.
So that's where we're at.
History behind it.
Okay.
In person, or is it all virtual?
We do hybrid. So people can come in person or they can attend via Zoom, whether they're members of the public or members of this committee. To Dave's point, I think
I think you're right, because I was working at the state bar during that time when this rule was drafted and proposed and during that kind of changeover. And it did seem to make sense then, but it's been 7 years. So maybe at this point, it served its purpose. We don't need that language anymore.
I didn't get permission to substantive change on this one, so. If we need to take that out, we can take it out. Okay, it's deleted. All right, so then we have the chair and where staff comes from, and then opinion requests. Who may request an opinion? Any questions or concerns, John?
Justice Mike, just consistent with the format used in all the other rules, for 1 and 2, each of the major words should be capitalized. You know, it could be capital May, capital R.
Okay.
Containing submission of a request, capital R. I'm really good with those.
You're earning your paycheck. So any questions or concerns about restyling text? Again, for submission of a request, this is all restyling. There's nothing substantive in it. Seeing anything, we'll move down to F for consideration of requests. Questions or concerns? Okay, moving right along then to G, written opinions. And again, this is restyling. This tracks the current process that's used. And then we're down to H. The only thing we changed in here was instead of, originally it read, state or health request comment by being opinion. So, and then yeah, we changed promulgating or distribute the posting. No concerns. Move down to the next. Report review. Yes.
Two picky points. This consistent with Garner. Says after completing the process described in section, his recommendation and what we've done in most of the other rules is just refer to the strike the word section, just refer to H.
Okay.
And then further down, it says within 90 days thereafter.
After 90 days?
The convention we use no later than 90 days after proposed opinions filing. I've run into some problems with some of the rules when they talk about within a certain period, because you might take action before that happens.
Any other questions or concerns? Okay, we'll move down to J. This is the same process we have now. And instead of promulgating now, the state bar will post. Questions or concerns?
Yeah. All right, we're talking about promulgating.
Really lawyerly sounding though, I mean.
Yeah.
No, just more syllables. Okay, down at K for reconsideration. Again, this is big substantive here. It's the same process. Yes, John?
One more, same, like, instead of saying within 30 days, let's say no later than 30 days.
Okay. Any other questions or concerns? And then this is, the opinion as a defense, word reads exactly the way it did before, except to say, referencing the committee, we reference the EAC. Questions or concerns? That's the rule. Move on to Rule 44.
Yes, sir. This is the legal specialization rule, and we really didn't make what section. It's all stylistic, and there's nothing substantive. Paragraph A, we omitted what was the original language and instead inserted the specific language in the mission statement found in Administrative Order 25-26. So that's verbatim that mission statement. In paragraph B, we just changed the language a little bit, shortened it, and changed attorney to lawyers to be consistent with the balance of the rule changes that we proposed. Now, in paragraph C, you'll notice there are two places where there's alternative phrasing. The language in there now says members of the BLS will be nominated by the Board of Governors and appointed by the Arizona Supreme Court. Alternative one, the Board of Governors will nominate and Supreme Court will appoint BLS members. Two, the Board of Governors will nominate and Supreme Court will appoint the BLS chair among the BLS members. So it's really a matter of, you say tomato, I say tomato. If anybody has any strong feelings in favor of either alternative, speak up now or for hold your peace.
I think the alternatives are much better because they're in the active.
What do you like best, John?
The Board of Governors will nominate and the court will appoint us members.
I think I agree. I also and I know this is partly because we've included some alternative phrasings, but this is pretty long and I really think it could stand some substructure.
Tell me how you would do that.
Go back up to the beginning of the section. Thank you. So composition.
Amy, can you speak up just a little?
Sorry, I'm saying that I think there should be some substructure. And Don asked how that might look. And so I scrolled up to the top. I hadn't really recommended something yet. I'm wondering if first we should say in a different section that should be the original C, the Board of Governors will nominate and the court will appoint BLS members. And then a different, like section D, that would be composition. And then we go to the 13 members. So I realize I'm kind of complicating this a bit, but I think it'll look more clear once we make then composition a D. Yeah. Okay. And so nomination, thank you, Kent, for C. Nomination, yep, composition. And maybe something to the extent of, actually, I'm wondering if we could then just make E the term limits. BLS members will, keep D where it is and then make an E and take that BLS members will serve 4-year terms with a limit of consecutive terms. And then term limits.
Or terms, yeah.
Or just term.
Yeah, terms.
Terms would be fine, yeah, because we also talk about the length of term. And nominations, that section could go back up to, actually, you know what? Actually, bump it back down. Sorry, back down. And then make an F for chair. And I think that kind of solves the issues I was having. What do people think?
Well, or go back up, please, Veronica. To C, and we could make C then BLS members, and then C1 nomination.
Sure.
C2 composition.
Sure.
And then C3 terms.
That'd be fine.
Make C.
Yeah, I think she's doing it. Yeah. Is that what you had in mind, Justice Montgomery?
Yeah, that's.
Yeah. And then, yeah, terms.
Seems like chair should go up closer to composition, maybe following composition.
Well, then we would make chair could be. There should be the first one.
Yeah, we can make chair the first one.
Please go up a minute, Veronica, take a look at this. Now BLS members, that would be C. And then C1 could be the chair. And then move the Board of Governors will nominate and the court will appoint BLS members and put that within C2. You're fine right there. Right there. Go back up up a little bit, please. So the sentence that reads the Board of Governors will nominate, take that and make that the first sentence underneath C2 composition.
That could all be merged into B, which is entitled board.
Well, the thing we're trying to do is add structure though, not merge too much into one big paragraph.
It would all be, you'd still have the same subdivisions. It's just all under board.
Can you scroll up a little bit, Veronica? A little bit more. Well, then we would go B1 BLS members. Then we'd have B1A.
Yeah. It would just be further indented. Would we have a B1, a B2 then though? Would be my only concern.
Yeah, we would still separate the chair from the other membership.
No, I agree with that, but so you're saying it would become a B1A chair, B, C, but my concern is would we then have only a one subsection of BLS members to one subsection under B?
Oh, I see what you're saying.
Yeah.
Well, let's delete composition BLS members. And then we would just address then chair. And then two, to the composition, just have that read members.
Okay.
Scroll down. And actually, we could put terms, BLS member terms. Well, no, that would encompass the chair as well. So we could have that separate. Okay, scroll down a little bit more, please, Veronica.
Yeah, that fixes the concern I had. I think it makes it more clear.
Can I ask, just to compare to the Ethics Advisory Committee, if you could scroll up a little bit. 42.1 says Ethics Advisory Committee, open paren, open quote EAC, close quote, close paren. And then the first sort of chunk of it is membership. I wonder if using that sort of convention here for the title, right now it says legal specialization. I think what we're talking about here is the Board of Legal Specialization. Go to A. Right there. Yeah. Does it make sense to have this be the Board of Legal Specialization and then to use that same convention, open quote BLS, close quote, to put that right in the heading?
Well, or either that, or I see what you're saying, or it should read legal specialization program, because the AO set forth the purpose for the program, and that was in the previous rule. And then the way that's administered then is underneath a board, which is set forth in B.
Got it. Is that? Well, I wonder if, in other words, consistency from rule to rule, where it's warranted, and it may not be warranted here for the reasons you.
Yeah, because you raise a point. So, Veronica, if you could go up to Rule 44 and have that read legal specialization program. I mean, that would distinguish it then. Okay, I think we can carry on.
Okay, anybody want to overrule Justice Montgomery before we move on? Yes, not.
Subject to John?
Yeah, one of the conventions we've used in the past was telling conventions, any number above number 2 is a number, not a word. So now we just describing how many members there were.
8, 13.
13,
Yeah.
yeah.
He's correcting them faster than I could find him. Veronica's the MVP today, I'm telling you.
Yeah. Now we go down to the paragraph called limitations. And we just moved things around here a little bit. The original language said the BLS may not require a lawyer to be certified in order to practice in a particular area. And what we have changed it to say is the BLS may not require a lawyer to be certified to practice in any particular area, but they have the right to practice in other fields or to associate with lawyers in other fields. That's not a substantive change, it's more stylistic. The following paragraph, discretionary review, this is the one that we not certain if this was a substantive change. We took out the word verified so that when a lawyer doesn't like a decision by the board and files a petition, the original language says that the petition has to be verified. We've suggested taking it out because petitioning lawyer is going to sign the petition anyway, so, you know, it's belt and suspenders. Any thoughts on that?
We thought this was more a process thing to reflect the actual practice.
Yeah, yeah.
So verified should come out?
Yeah, that's what we're
Right
thinking.
now.
Yeah, that's what we're thinking. Assuming it's not a substantive change.
Don?
I don't think there's any reason to even verify it. It means kind of archaic. I mean, we're trying to get away from that in the civil rules. I don't know why we would want to do this here. I would also suggest that in the first sentence, instead of saying within 20 days, say no later than 20 days. And in the second sentence, refer to the petition's basis instead of the basis of the petition.
Yeah, okay. No later than 20 days is consistent with the other language. So yeah, I think that's a good idea.
I'm just gonna be devil's advocate here really quick. Is aggrieved the right word to use? A lawyer aggrieved by a decision of the BLS? I mean, I'm assuming it's the lawyer that had applied.
I don't see why you can't say a lawyer who disagrees with a decision of the BLS, like.
Or what,
Is the petition denied?
Who? We want to limit it to the lawyer who filed the.
That's what I meant. I thought, oh, could I be some aggrieved lawyer
Right,
who
right.
just doesn't like the whole process? So I'm gonna.
Yeah.
That's fine.
So.
Agreed to term is hard.
So you want to make it explicit that it's the lawyer who applied for specialization and was denied.
Yeah.
That's what I think the intent was, and I didn't know if that captured that intent.
But if the board denies the petition,
Well, just files, I mean,
The applicant or however you want to designate the.
and we've actually gotten to these.
What do you,
Yeah, I'm not surprised.
from someone that just didn't like the whole,
It was denied.
they were denied. Okay, I thought you meant someone like.
Agreed.
I was just, you know,
It's like, I would
well,
agree.
They didn't want someone to be granted special, no.
Oh, so they were.
They were denied. They
You
were
were
denied.
my like a competitor. like
So, but
you.
doesn't aggrieved actually mean who applied for specialization and disagreed with?
I don't know if it does. I mean, I would have to find it in Black's Law, but I just did a quick
I see what you're saying,
dictionary
because like
search
that's
and it
like
just
just
says.
yeah, someone who thinks someone shouldn't have been a specialist.
Yeah, there is case law
Yeah.
saying that
Wondering, right?
you can be aggrieved by a decision.
Yeah,
Oh, okay. Didn't know that.
Yeah.
yeah, I think that is a good catch.
Okay.
I could see somebody saying, Jessica Fatinas is not, qualified enough to be a specialized whatever, or yeah, we don't want that to happen.
Decision rather
with
than.
me. I'm aggrieved.
Quite nice.
Sorry, Lisa, what were you saying?
We had a decision and it should be the decision.
Yeah. Mhm.
We shorten it down to a lawyer who is denied specialization.
Yeah.
I think then you could take out and disagrees.
Yeah.
Yeah. Then just be by the BLS?
Yes.
Are the only choices denial or granting? There's no like conditional or conditional.
I've never been part of BLS.
Forty-four.
Did it be the court instead of this court? And that.
Oh, that court?
On that one. And should the 30 days be no later than 30 days?
Just took John's candy from him.
Well, and just to be consistent.
Yeah, so yeah, the bill also have no later than 30 days.
In Rule 36, it uses a lot of the same language. Within 20 days, person aggrieved. And so if we're doing it over verification, so if we're doing it in the BLS, we may want to know that for purposes of challenging petitions for review from admission decisions. Right now, they are, I think they track each other.
We're ready to move on to Rule 45?
Yep.
Okay, Mary?
So Rule 45 is mandatory continuing legal education. And much like the previous rule, this was really about reorganization and restyling. So you're going to see a lot of the same language, but I think we kind of just moved things around and just organized in a way that we thought made a lot of sense. So we start off with sort of the general requirements, moving into the more specific requirements, and then the methods by which one would earn the credits necessary to comply and what qualifies in that regard. And then we, excuse me, move into exemptions, followed by delinquency. So starting at the very beginning, looking at the general requirement for the 15 hours, again, wording is just kind of tightened up a bit, but no substantive changes there. So any questions or concerns with 45A?
I have a question or concern just with the title. Why change it from mandatory continuing legal education, abbreviated MCLE, and change it to required instead of mandatory? I just feel like that's going to cause an administrative headache for the people in the CLE department, for example, because we always use the term MCLE.
Yeah, and I don't, does anybody recall what the conversation was, or were we just trying to?
Because we require continuing legal education, but in this rule, we talk about all these different options and ways you can do it, rather than saying that this is mandatory CLE with mandatory things that you have to do beyond the 3 hours of ethics.
I'm just saying, because it's a term that's been used so long that we have, just from my recollection of CFAR.
It's fair because everybody
is like
refers to it
baked
as
into so many, like
MCLE.
the
That's fair.
websites and stuff.
I've started calling it RCLE already, so.
Are you serious now?
No.
It's like, wow, I'm impressed.
I don't think with the short sight on the heading, I don't think you then need the second abbreviation. See the quote CLE close quote in A. I think you could easily strip that out. And then we inject MCLE, which is not a defined term in there. And I think we ought to take that out as well. So do you mean for regulations, is it CLE regulations or is it something different? I think it's CLE regulations.
They do say MCLE quite a bit though, when it comes to like filing your affidavits.
Yeah, I get it.
They're probably MCLE.
I get it. I just, if we're referencing MCLE, we should say what that is because we haven't done it yet.
Well, because the title used to be mandatory continuing legal education, yeah.
But which is, and the CLE now means required continuing legal education. So I think we pull the M out of there.
All right.
Do we want to say about having to
the
change
term.
letterhead?
Personally, I don't think that this is a significant enough reason to change MCLE to RCLE.
So we can change required back to mandatory.
I think we should.
This is your rule, Merit.
I don't think
It's not the first paragraph this time. All right. So thanks, Anne. I appreciate that. Any other thoughts about A?
The M should still come out. It should just be CLE.
Then you want an M in the, since it's back in the title.
Yeah. I
Or
think you
use the
want to-
short side, use the acronym MCLE throughout. I don't really care. It's just,
Yeah, should be in CLE then. So Veronica, at the end of Rule 45 in parentheses, instead of CLE, you make that MCLE. And we can resurrect the M.
Yep.
So it would be MCLE regulations after all. After June, if you go after June 30th, Veronica, if you undelete M. There we go.
Okay, perfect. So then we move on, section B, for professional responsibility requirements. You need 3 of your 15 hours need to be in the area of professional responsibility. And then their subsection drops down and defines what types of things would constitute professional responsibility credit, right? So again, we did not add anything to this particular paragraph, but we did kind of reorganize.
So when we have a long list like that in subsection 1, potential topics, I do know the Garner Convention is to make that a potential list, substructure. I know that there may be reasons not to do it, but was that considered?
Other than having 1A through Z.
Yeah, which I realize would be a decent amount. But it is something that's in the Garner Conventions that we're trying to discourage these long lists like this.
Mary.
Ends up to 10.
Yeah. It would be a lot.
It would be a lot.
It would be easier to read.
It would be easier to read, and it's a lot right now. Like we're kind of getting a lot of these big paragraphs.
Judge, I really think if you try to list, that's gonna be really.
I know. No, I get that too.
Yeah, it's like a long list or a long sentence. Choose your.
Do we need to have this many examples? Or
If you're gonna turn in your affidavit at the end of the year and you get audited, you're gonna want to be able to point to exactly why it was authorized.
well, and so I guess I'm just wondering, because I feel like with this last couple of topics, we've had lots of long paragraphs, and I'm just concerned that we're drifting back to what Garner told us not to do. I'm not saying that we should change this paragraph. I'm just kind of wanting to point this out generally, that we're starting to drift away from the conventions.
Well, they had a long list of distributees on 123.1.
Yeah. We did, but that was a list.
I think you have a good point, Amy, especially because there's so many commas in there. So some of these things
break
are
it out then,
multiple
see what it looks like.
commas. One topic.
And so then it would be include such topics to the extent professional responsibility is directly addressed, such as, and then a colon, and then add the structure.
That I think is a substantive change. Because the presumption currently is all of these topics, regardless of the content, qualify.
I agree.
Well,
They have to see it.
It says it at the end.
The end, the last sentence was a qualifier.
Yeah, that's true.
Yeah,
Yeah, no, I wasn't trying to
I
make it.
I don't think it's substantive.
Yeah.
That's true. No, I get it. No.
Yeah. And that's more proof that it's difficult to read this paragraph.
Oh,
wait, no.
Sorry, not those. And again, this is, so causes, prevention, detection, and treatment alternatives for substance abuse is A. Then D would be attorney fees.
Client development.
C would be client development. Yeah. So, yeah. Yep. And conflict stress management. Yeah. Does anybody ever mean copyright, or does everybody have to constantly change that?
Never meant copyright.
I never mean copyright. I never mean euro
You
either.
go in, you can change.
You can.
You can. Real quick, should E and F be combined, dispute resolution and other alternatives litigation, or were they meant to be separate?
It's a good question.
I would say we combine as many as we can.
Yeah.
And this is so it ends up-
Because I think client development's also part of law office practice. So
Yeah, I think you can combine C and D as well.
If you're making a list, there should be semicolons and not.
Yeah, but yeah.
Was we left out disabilities part of their. I mean, just a minute ago.
You mean managing conflict and stress manage?
Yeah. Yeah. You can combine that with stress management.
I think that conflict reserve doesn't necessarily deal with stress.
Yeah, I agree.
Okay.
Because I think that
Conflict
managing
is-
conflict could be a different, de-escalating people in court as opposed to it, yeah.
So the way to
May
manage
cause
stress.
Yeah, true. And yeah, and then age, that's honestly, that isn't that long.
Did you want to combine C and D? I think you
Oh, yeah.
recommended, Amy.
You mentioned combining client development, law office, economics and practice. I don't know if we want to do that though.
Maybe.
I think leave it as is because you can do things like ethics of managing a trust account. I know we haven't gotten to trust accounts yet.
Yeah.
I'm really excited.
Wait,
How was it client development?
Shows the very top of this.
Oh, talking about ethical ways to advertise and
Solicitation.
solicit.
Capital letters.
Yeah, I'm talking about the size of your building. That should be one, should be capital R, it should be capital E. Down below for do the same thing, capitalizing G, government lawyers. Yeah, exactly. G. And then in the very top, have B. Further up, open. The clause that's right in the middle of the sentence, each educational year kind of gets in the way between the subject of the sentence and the verb. So I would suggest saying for each educational year, comma, minimum 3 hours.
How about this? A minimum of 3 hours for each educational year.
That would work too. Rather than saying section A, just say A. Then in 2, that's within 1 year, I would say no later than 1 year.
Okay.
Back up to A. Thanks. Right, nope. Can we change just to make it, I think, consistent with today's terminology, rather than substance abuse, substance use and mental health disorders?
Oh, it's good. Yeah.
Don't forget the Oxford comma. Use. I caught that one.
That's not where the Oxford comma goes. Because it's causes prevention, detective and treatment alternatives for these two things.
Okay.
So you don't Oxford comma it there. But I do appreciate it because I do want the Oxford comma.
Justice Montgomery, I know you led the work group on it. When we scroll down, the requirement for government lawyers, was it contemplated in your work group, those that contract for government work?
That's all defined for, it depends on what they're doing,
Okay.
whether or not they fall within it. I think that took a whole day.
I have no doubt. I just didn't know if we wanted to then
Yeah, no,
allude to that.
That winds up, it's defined over there.
Okay.
And definition of whether it's employed. I think that under the rule, it talks about who the rule applies, to whom the rule applies and it's employed. Or
Okay.
elected or,
So 1099 would not be employed, they'd be contracted.
that's my reading.
Selfishly, I do a little work for Graham County, so I wanted to know if I had to take it.
May not be the reading.
So I refer you to the rule.
I agree with him.
What, instead of substance abuse, what about using the phrase chemical dependency? That's in the ABA standards.
The substance use is broader than substance abuse, right? So it's the misuse of all kinds of substances. Chemical dependency, I agree. I mean, I know that it's.
Just throw it out there.
Substance use disorder is in the DSM. The Diagnostic Systems Manual, and so when we pair it with a mental health disorders, I think it makes sense to use the similar terminology for how we define mental health disorders. I see where you're coming from about chemical dependency as well.
And I think chemical dependency is the same as substance abuse, right?
I don't know.
I think it is.
I think
But
it probably is.
all right, so, oh, sorry. One thing, so I did just look this up and I found one definition that highlights a potential difference, which is addiction is both physical and psychological with chemical changes in the brain leading to the behavior. Sometimes when they define chemical dependency, they think about it as physical manifestations alone. And this just comes from the San Antonio Behavioral Healthcare Hospital. But I wonder if we can look at chemical dependency, such as withdrawals from things like a benzo that might be prescribed to somebody. But people are chemically dependent on a benzo. They cannot just go cold turkey on it or they might die. But that doesn't mean that they're addicted to it, not in the way that we discuss it.
That be underneath substance use.
Substance use encompasses
That's
that.
why I think substance use encompasses it better than chemical dependency.
Right.
I think you can have a chemical dependency without having what we classically think of as an addiction.
Or you might just be a little too reliant on substances without being addicted or dependent. Maybe it's just not.
Yeah, this is how to responsibly moderate your intake,
Yeah.
like alcohol or a legal substance. So I think use works better.
Keep it broad.
Okay, so what's the next paragraph? Oh, methods of earning credits.
So I think that we drafted this, but we kind of left it in terms of understanding that we would probably need to come back around because this certainly wouldn't encompass all the methods by which one could earn credits. So I'm not sure if we want to just leave this with a pin in it for right now and move on to the things that we did finalize.
And Merritt, could we go back to the list we just did? Because I appreciate what Amy said about the DSM. So I looked at the DSM-5 and it uses mental disorders. It doesn't use mental health disorders. So I wonder if we should omit health.
Okay with that.
Or do you want to keep it broad and say something like mental health issues?
Well, that's why I look
Yeah,
at it, 'cause
yeah,
I don't
to be-
love the disorder term, but I get what
Right.
Amy was saying is let's try to be
Well,
consistent with the DSM.
Well, and that's when we were using the phrase disorder. I don't have a problem with saying mental health issues again, so that we can keep.
I like that.
Yeah.
Substance use.
So it
and
doesn't have to be
mental
limited to
issues,
people with
yeah.
a clinical diagnosis. Or to leave the state certified.
All right, so back to methods of earning MCLE credits, right? So subsection C1, serving as an arbitrator under Rule 73. Again, I think there were just a few words that we changed, but the substance remains the same. Same with subsection 2, which is providing pro bono.
I wanted to capitalize the major words in the title. And I think we already defined, I think in Rule 1, procedures refer to Civil Rule 73. And you need to do your application.
Ooh, can I ask, 38D2A defines pro bono services as civil legal services provided without charge to low-income clients. I wondered if we might be able to remove to the poor or near poor. And to use instead pro bono services, I think that should be S. And the heading uses poor or near poor. I'm not sure, although believe me, I've not committed 38D to memory. that 38D uses that phraseology. I think the definition of pro bono services could do the work. Unless we're talking here about a subset of pro bono legal services, and I don't think we are.
Well, I think we're talking about the ones that are done through an approved legal services organization.
Absolutely,
Yeah.
still there, but in the heading, provided pro bono services through an approved legal services organization.
It should be sufficient.
Yep, and then I think hours of pro bono, maybe not, but I thought maybe pro bono services provided up to a maximum, but I might be wrong on that. Yeah. Thank you.
Can I go back? Word 5 needs to be changed to the number 5 in the first sentence.
Can I go back to paragraph 1? We're not including FASTAR. So in Beaver County, we don't use Rule 73. We have Supreme Court FASTAR, and other counties can adopt that. I don't think we're gonna put that in there, but
Would you put a pin in that one? We'll have to go take a look at that and with approval to make a substantive change.
That should be better represented here.
Add that.
Yep.
Judge, I said Pima County should just be better represented here, the.
Well, and technically, we're just making the change to conform with the law.
So let it be said.
Doesn't count as a substantive change that requires approval by the chair or vice chair.
All right. I didn't want to make that decision on my own.
For clarity, can we go down to number 2, the providing pro bono services to the full text? Up to a maximum of 5 hours of CLE credit per educational year. The of CLE credit should be moved to after, no, not that part. 1 hour, so it should be 1 hour CLE credit for every 5 hours of pro bono services provided, up to a maximum of 5 hours of CLE credit per educational year period. I think it's confusing otherwise. That means basically up to like 25 hours of pro bono.
5 hours that you can take.
Yeah.
You get one.
Right, yeah.
Right.
I had a question. So under Rule 38,
Yep.
I did look at it. I have it pulled up right now, and it does say, talks about it, and then it says pro bono services in quotes for civil legal services provided without charge to low income clients through a legal service organization.
Correct.
Do we need to call out that, or is it inherent in pro bono services that they're flat out without charge?
I thought the reference to 38D.
Covered that.
Yeah, but if we need to make it more express, we could.
I think it's okay too. I just wanted to make sure that.
Do people get credit at all for doing modest means or no? A modest means project?
I don't think so because they get paid.
Yeah, I know they don't get paid much, but they get paid something. I just didn't know. Yeah, I just want to make sure we weren't.
Moving on to C3. This is participation as an arbitrator for a state bar fee arbitration resolution. That's what? One of the new orders. C4 references.
Good to before. So reference, this talks about the program is eligible for 2 hours of continuing legal education. Actually, the convention is word, for 1 and 2, you use the word.
state water.
Can we change auspices to something else or?
But I just, it feels a little. Yeah.
Say under the state bar.
Under the authority,
Take it out.
maybe, or just under state bar arbitration.
Yeah, there we go. Just
Under the state bar fee arbitration.
So Veronica, if we can go up to the header for that subsection, serving as an arbitrator for a fee dispute resolution under the state bar fee arbitration program.
Can I ask what, under for a fee dispute resolution adds here? Because last I knew, at least the fee arbitration program, you can resolve fees and cost disputes. So would that carve costs out? Are we wanting to do that? I don't think we are.
And I agree. I think I know where you were going, but I would just say serving as an arbitrator for the state bar fee arbitration
I
program.
like your
Think
thinking.
about
I like your thinking. Yes.
So we would delete a fee dispute resolution under the auspices of.
Yep.
Yeah.
So that you do that.
In the heading.
So go up in Veronica, on the third line, who served as an arbitrator for the state bar fee arbitration program. So for.
Maybe we should get rid of all it.
There we go. Thank you.
And to strip similar text out of the heading, right?
Oh, served as an arbitrator for
Just
the
make
state
it
bar fee
for the
arbitration
state bar.
program.
Yeah.
So in the header, Veronica, we could take out a fee dispute resolution under. Thank you.
Do we need activity before credit? I don't think for like when you're doing pro bono, I think it's just you get CLE credit.
Yeah.
Any other thoughts about C3? No, but I have a thought about C2. So C2, to go back to C2, there's a highlighted sentence. For pro bono services, this credit will be included in the maximum number of hours allowed for self-study. And not all of these exceptions, there's a mix of all these exceptions of how you can qualify for CLE credit. Some say you get self-study hours, some don't put that limitation on. There's a limit of the number of hours you can accrue based on self-study. And it seems like if you're actually providing hands-on pro bono services, it shouldn't be limited to just self-study. You should get.
That would be a substantive change.
That would be a substantive change.
That'd be a good one.
I mean, for example, if you do a fee arbitration, it's just you get credit. It's not limited to self-study.
Arguably, that's less valuable to the public at home.
Arguably, that's less valuable to the public. So my point is under two, you're providing hands-on services, pro bono services, and you're limited to qualifying for some self-study credit.
I agree. And recognizing that would be subject to the discretion of the chair and vice chair.
No pressure.
To consider it another point.
Think about it.
Veronica, could you put a note on that? Subject to a determination by the task force chair.
Worthwhile endeavor. Do you want to add that note for C1 as well? Because it has a similar limitation.
That's more, to me, that's more like the fee arbitration. You're serving as an arbitrator. And so maybe that's a different calculus because it's.
But right now it's limited to self-study as well. But the arbitration isn't, right?
Correct.
The arbitration is not, correct.
I'm not saying we have to, but I'm just saying that's another potential inconsistency.
Yeah, I think the two arbitrators should be treated the same. I think you could argue the pro bono should be treated differently.
Yeah.
But I don't see how you can justify having arbitrator under Rule 73 and arbitrator under the state bar treated differently.
Yeah.
Well, do we want to incentivize people to do it? That would be the only.
Just when they send it to me, I just do it.
Maybe flag that one for substantive change as well, that self-study C1. I think something to think about would be what's the purpose of having a limitation? Like maybe it was put in there for some reason. One reason I can think of is
trying to encourage people to do CLE seminars, because I feel like that's considered the preferred version of getting CLE credit. And then limiting other versions, but maybe it just doesn't make sense in light of the recent rule changes we've had.
All right.
All right, well, this seems like a good time to stop. We're at the end of our appointed time, unfortunately.
Got so close.
You see the tear?
Only submitted on this.
All right, well, move on to agenda item number 5, which is roadmap. A couple of points on this. We've recently decided to reassign rules on attorney reinstatement for work group 2, work group 4. Work group 4, by way of reminder, was designated attorney discipline rules. And so Justices King and Montgomery and their respective work groups have agreed to transfer the rules on reinstatement from the group 2 has to work group 4.
For cash and the player to be named later.
Is going to follow up with both of the work groups, and he'll memorialize this transfer of the rules with detail, identifying the specific rules that are being transferred from work group 2 to work group 4. Now, it's possible that there may be other reinstatement rules that we've overlooked that are assigned to other work groups. If you, in the process of going through your assigned rules, you find work group or rules that apply to attorney reinstatement, would you please reach out to work group 4 and discuss the possibility of transferring those two so they can all be consolidated with work group 4. Again, I don't know if there are any, or if so, how many there are, but we should probably make sure that we're consistent and have handed all of those matters over to work group 4. Now, the second point in roadmap concerns the task force meetings. We have meeting dates, which you're aware of, for meetings 4 through 7. Meetings 8, 9, and 10. We have dates in March. These have been provided to the members. Is that correct? Meeting 8 is tentatively scheduled for May 11th, meeting 9 for June 12th, and meeting 10 for July 20th. Now, we had some trouble finding dates that worked for everyone on meetings 8, 9, and 10. So by way of reminder, if you can't attend personally, you're invited to attend virtually. And if you're not available at all, please keep in mind your option to designate a proxy to attend in your stead for meetings 8, 9, or 10. Any questions about reassignment of rules or scheduling of the next meetings? All right, Justice King. Oh, yeah,
I
David.
did get an answer about the Dropbox, where we had that. All superior courts do not.
Well, I think that thank you for letting us know. I think putting in where available probably covers that anyway. I mean, does anybody think that putting in where available takes care of any implication that there's an obligation to provide that people would start filing suits about? Just want to be sure, but thank you for letting me know, Dave.
Yeah. So the last item on the agenda is really the call to the public. We already did a call to the public, but in the interest of, allowing people, I don't think anybody's on, so that call to the public has been declined by members of the public. And then the final is just to adjourn the meeting. So thank you all for your ongoing work. Our next meeting is December 9th and the meeting is adjourned.
So I'm sorry, real quick. Are we adopting these dates then? The possible dates? I just wanted to be changed.
Yes.
Yes,
Okay.
I think that, yep.
Great.
Yeah, I think that was the bad option in terms of. And this is just.
Who goes by, this is a public service on YouTube.
This is a public service.
This is a public service.
We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service.